Gentlemen, to the rescheduled October meeting of the San Francisco Ethics Commission. And I will call attendance. Commissioner Keene.
Here.
Commissioner Hayen.
Here.
Commissioner Chu.
Here.
Commissioner Kopp.
Here.
All right. All commissioners appear present and accounted for. And before I go to item 1, because of some incidents at the September meeting, I have asked the executive director to print in the notice of meeting a paragraph headed "Meeting Decorum." And it reads as follows: The Ethics Commission encourages and promotes integrity in government by education and example, and is committed to treating all staff, members of the public, and colleagues with courtesy, respect, objectivity, and fairness. Members of the public who attend commission meetings are also expected to behave responsibly and respectfully. Persons who engage in name-calling, shouting, interruption, or other distracting behavior may be asked to leave. The following behavior or activities are discouraged inside the hearing room: applause or vocal expression of support or opposition, eating or drinking, profanity, and physical aggression. In accord with the Board of Supervisors Rules of Order 1.3.1, signs, regardless of content or message, are strictly prohibited. This prohibition does not apply to clothing, which includes signage pinned to clothing, messages displayed on clothing, pins, hats, or buttons. If the chair is unable to obtain voluntary compliance, he may seek assistance from the Sheriff's Department on call. This provision supplements rules and policies adopted by City Hall, the Sheriff's Office, or the Board of Supervisors related to decorum, prohibited conduct or activities, noise, etc., and is not meant to be exclusive. This notice will appear on all future notices to interested persons of meetings of the Ethics Commission. I'll call now for any item number 2 for any comment, public comment on items on the agenda or not on the agenda.
Over there, he's doing it.
I know. And I will. I would urge people, if your comments relate to item number 7, the Farrell matter, I would appreciate it if you would hold those until we get to that item, at which time we can discuss them. All right? Any public comment?
Are you taking public comment on the meeting decorum you just read?
Anything.
You didn't answer my question. You just had an item on the agenda unscheduled about meeting decorum.
That was.
Are you taking public comment on meeting decorum?
I'm saying that was just reading from the notice, and I'm simply now asking for public comment. If you want to comment on the decorum, that's fine.
But that is not public comment item 2.
No.
Correct?
No.
Okay.
And I would ask you to put the sign down, please. All right. You want me to ask the sheriff to come? All right, I will. Would you call for the sheriff? You've got a sign on your shirt. That should be enough.
We got information from the sheriff directly that there is no prohibition on signs, and it's in their rules. And the Board of Supervisors also sent us information saying there is no prohibition on signs.
Go ahead. Go ahead.
Commissioners, I'm Larry Bush, here for Friends of Ethics, as well as for Represent Us. I just wanted to bring you up to date on the current list of endorsements for Prop T, the ballot measure that was put on by Ethics. I'll hand you, I have only one copy, but it's voluminous. And I'm happy to report that all members of the San Francisco delegation in Sacramento have endorsed it. All members of the Board of Supervisors have endorsed it. And I think there are 31 community-based groups that have also endorsed it. To the best of my knowledge, there's fewer than 5 groups that have opposed it. So I'm not sure that we can deliver the 90% vote that Chair Rennie asked for, but we're going to do our best.
Commissioners, Ray Hartz, Director, San Francisco Open Government, and I'm reading from a Field Operations Division Policy and Procedures, City Hall Security Unit, and it says signs exceeding 11 by 17 in size are not allowed in City Hall. Signs exceeding 11 by 17 in signs are not allowed in City Hall. It does not say there is a prohibition on signs. And what we got from the clerk of the Board of Supervisors says also, signs mounted on sticks or poles are not permitted. Banners are permitted only when special license. Small paper or cardboard signs no larger than 11 by 17 that can be carried by hand are allowed. So you're saying in this thing you just read that the rules of the board say no, and the clerk of the board says you're wrong. I'd like to comment on a couple things that did happen since you brought up the subject. First is to Commissioner Keene. While I fully appreciate Commissioner Keene's explanation about wanting to help Mr. Petrellis in presenting his case, he had 5 minutes. And I don't know about anybody else, but when I'm going to be presenting a case, I do very careful preparation, and I use the 5 minutes. And when I'm interrupted in the middle of my 5 minutes, I consider that a breach of my First Amendment rights, just as any of you, if I interrupted while you were speaking, would consider it a breach and grounds for removing me. And as 4 of you out of the 5 are attorneys, I would like to use the comparison. You can advise a client to do anything you think is possible, but the client has no obligation to follow your advice. And very often, if I'm the speaker and I only have 5 minutes, I may not want to go off on a tangent, and I may want to use my 5 minutes to its most effect. And I think I should have the option of saying thank you for your help, but no thank you, especially given the help that I normally get is 99% of the time nothing but an attempt to throw you off track. To Supervisor Kopp, he asked people to identify themselves, and I'll read from the Brown Act, rights of the public. Under the Brown Act, a member of the public can attend a meeting of a legislative body without having to register or give other information as a condition of attendance. And while I appreciate the fact that Supervisor Cobb is certainly free to say that if you don't identify yourself, I won't give you as much credit for what you have to say, he is entitled to say that. However, he is not entitled to tell a person, because the law goes on to say that if you ask a person to identify themselves, you must tell them they are not required to do so. Now, that's just a couple of examples. I don't have a lot of time, but isn't it kind of a shame that I, a member of the public, have to come here and read the Sunshine Ordinance and the Brown Act to the ethics commissioners?
Thank you.
Mr. Chairman, may I ask the gentleman a question?
Yes.
What section of the government code is that?
It is the Brown Act as provided by the Attorney General.
It's in the
Would you please let me answer the question?
Please
you want an answer or not?
my question. What section of the government code is it? Thank you.
Any other public comment?
Hello. My name is Michael Petrellis. I'm a proud candidate for the BART Board District 9 seat, and I believe this body has been infringing upon my First Amendment rights. At the last meeting, you directed the Deputy City Attorney to come up with an opinion about signage and free speech at this body. That item is not on the agenda. I have not received the opinion from the City Attorney. However, on October 11th, the City Attorney responded to me regarding a Sunshine Ordinance complaint I filed against this body. And the City Attorney has written, this was about what happened last month, that there was no violation because the City Attorney's office was not and is not in possession of a written policy prohibiting political signs in hearing rooms other than the policies already provided to Mr. Petrellis by the sheriff. I repeat, the city attorney's office was not and is not in possession of a written policy prohibiting political signs in hearing rooms. Yet an ex-judge, a law professor, the spouse of the former city attorney, and 4 lawyers on this panel are trying to stop my First Amendment rights from holding a sign. I can wear a sign on my chest, but I can't hold a sign on paper. There is something wrong with this policy you're trying to promulgate without any public discussion. Now, because of last month's incident where you all were interrupting me and infringing upon my First Amendment rights as if this were your courtroom, which it is not. This is a taxpayer-funded room. The TV is taxpayer-funded communication that I should have access to. Vicki Hennessy, the sheriff, on September 27th, wrote to her chief of staff, Eileen Hurst. Vicki writes, I have reviewed the security items I have and do not see a prohibition on signs. The only thing mentioned is signs mounted on sticks and poles are not permitted in City Hall. The city attorney and the sheriff are telling you there is no law prohibiting my First Amendment rights to hold up a sign that says, Michael Petrellis for Bart Board. You must start honoring the First Amendment protections guaranteed to me and allow me access to taxpayer-funded television. Thank you.
Your sign was mounted on a stick, so your own language contradicts you.
Any other public comment? All right. Turning to agenda item 3, discussion and possible action on draft minutes for the Commission's September 26, 2016 regular meeting. Any comments from any commissioner?
Mr. Chairman, on page 3, there is at the top the sentence that begins, the reason being that body such, I think the word should be such as this, not such of this.
All right. Any other commissioners' comments? Do I hear a motion?
So move approval.
Second.
But somebody wants to
Public
speak
comment?
on the minutes.
Thanks much, Commissioners. Charlie Marsteller for the record. On page 4 at the bottom, I was quoted as to the question of a subpoena power of the Commission. I said that I didn't think that it was necessary for the Commission to invoke its agenda powers a simple letter would do. So I don't want to toss subpoena around too liberally.
How would you like that to be restated in the minutes?
I've drafted something here, but I've also forgotten my glasses. So it said he stated that he was not sure whether the Commission needs to invoke its subpoena powers, comma, a simple letter should do. Welcome back, Ms. Hayden.
Commissioners, Ray Hartz, Director, San Francisco Open Government. I'll call your attention to page 2 of the minutes, agenda items 2 and 3, where you will see there a 150-word summary provided by me. The reason those are in there is because any member of the public, as ruled 6 times by the Sunshine Ordinance Task Force, if they provide 150 or word less or less word summary of their public comments, have the right to have those in the minutes. And the reason I do this is because public bodies cannot be trusted not to censor, abridge, mischaracterize, misrepresent, and otherwise abridge the rights of the citizens of San Francisco and of the United States. The bottom line is I say a lot of things you don't like. And so all of a sudden it becomes, we don't like your tone, we don't like you used a word. When the earlier thing was read at the beginning about there's no cursing, there is nothing in the law that prohibits me from using a curse. I'm not allowed to curse at you. But I have heard the member of the Board of Supervisors, Malia Cohen, refer to Mr. Petrellis as an asshole in a public hearing. So are you saying that public officials can call the public names like that, but we're not allowed to even use the word? Seems like a kind of double standard to me. I heard her sit in a Board of Supervisors full meeting and refer to something that one of the people had said as bullshit. I used that same word in a library commission meeting, and I just, oh, the children, the children. So there seems to be a double standard. You can set these rules, and very frankly, as we saw in the last item, you seem to pull these rules out of the air. And you can be told by competent authorities like the sheriff or the clerk of the board that that isn't a rule, and you will still sit there and insist on it. And when someone tries to say that's not fair, as Mr. Petrellis has tried, you stop them. You don't give them the opportunity. And I would suggest you read, what's his name? I can't remember his name. Norton versus the City of Santa Cruz, especially the concurring opinion of the Chief Judge Kozinski of the Ninth Circuit. He said it would be truly meaningless if when someone's right to speak were challenged, they were not allowed to the opportunity to rebut the challenge. And yet what happens in these things is a person in the chair simply makes a ruling. There is no opportunity for discussion, not even among the other members. And of course, none of the other members, even though they take an oath to support and defend the Constitution of the United States, will not stand up for a member of the public. They will simply allow them to be dragged off, which is an unlawful order and unlawful detention.
Thank you.
Hello, Michael Petrellis again, and I am still running for the BART Board District 9 seat. I must object to these draft minutes, especially under item 2, referring to my attempt to have 3 minutes of uninterrupted First Amendment protection, free speech at public comment. These minutes do not reflect the relentless interruption from the ex-Judge Kopp, as if this were his courtroom. There was no effort by any of you to stop his infringement upon my First Amendment rights. To see the 6 minutes that transpired reduced to these few sentences that does not accurately reflect how you were attempting to infringe upon my First Amendment rights is something I object to. Your minutes are not reflecting reality. Now, this relates to your meeting decorum, which is not a law. I wish to point out that in this meeting decorum, you say that name-calling is not allowed. Persons who engage in name-calling, shouting, interruptions, and other distracting behavior may be asked to leave. You also are prohibiting the drinking of fluids, and yet all of you have pitchers in front of you, and you've been drinking water in this room. I wish to point out the minutes do not reflect the name-calling from Peter Keene against me last month. The minutes do not accurately reflect the interruptions and other distracting behavior of you, the commissioners, when I was trying to engage in my First Amendment protection of expression by holding a sign. Your minutes need to be revised. along with how you are conducting the people's business in the people's building with taxpayer-funded SF-Gov TV broadcasting it. It is no longer okay for you to interrupt us and to call us names and to promulgate illegal meeting decorum, to silence speech you don't like. Shame on San Francisco's Ethics Commission that you are not honoring and protecting the First Amendment. Thank you.
Do you have any suggestions or revision to that part of the minutes, Mr. Petralis? Anyone else? I'll call the question. With the suggested changes from Commissioner Kopp and Mr. Marsteller, all those in favor of approving the minutes?
Aye.
Aye.
Opposed? Approval of the minutes is carried unanimously. Turning to item number 4, discussion of education and compliance program update. And I want to compliment the staff on what I think was a very good job of that memorandum, and I'd be happy to have you flesh it out and answer any questions that any commissioner may have.
Good afternoon, Commissioners. My name is Jared Flores. I'm the one of the Outreach and Compliance Officers. I'm joined here with Pat Peterson, who's the other Outreach and Compliance Officer. So basically, we created the Info Election 2016 as a snapshot in time report to really kind of showcase not only our campaign finance dashboard page, but also kind of tell a story with what's going on with the election this November. And we wanted to show how much contributions were being raised and how many independent expenditures were being spent in this election.
Any of the commissioners have any questions or comments on the memorandum?
Just like to compliment you on your work. You did a fine job.
Thank you very much.
And I'd like to associate myself with Commissioner Keene's remarks, Mr. Flores.
Thank you.
And I should say that what the executive director is in the process of doing, we're not there yet, but is setting up the agenda so that we cover every month the various activities by division and by responsibility with a report on them, and the agenda will be sort of in a standardized format to, if there's nothing to report, it'll be so, but it certainly gives an insight into what each one of these departments within the Ethics Commission staff are doing. I will call for public comment on item, I'm sorry.
Jared, I had a question for you. On the $29.1 million, is
Yes.
that more or less than what has been raised in previous years?
I have a feeling it's been a lot more, and in previous years, yes.
Do you have-
And as of, I believe, yesterday, that figure is now $34 million. Yeah.
Thank you.
I just wanted to comment and ask, while the charts are to a large extent self-explanatory, I just wonder if there's any additional elaboration or observation or analysis that either you, Mr. Flores, or Ms. Pelham would like to offer or, give at this time.
Right now, we're actually still in the process of reviewing all the data that's come in. We had a big filing deadline on this month. And so we're reviewing all the data just to be sure that all the committees are in compliance with all the state and local campaign finance laws. So right now, that's currently in review.
Great.
Just as a postscript, after each election, you'll recall, we do have the responsibility of reporting back to you and the board and the public about the public financing program. So we are hopeful that with the analysis that we're setting ourselves up for, as these numbers come in, that we'll be able to provide a more robust information to you after the election is over. I was asking our Shaista Shaikh, who oversees the audit and public financing program, what the figures look like historically. And she said these are pretty much on par with recent similar elections, but those were where there were a lot of candidates running as well. So we'll try and provide greater context for you when we have that analysis as the reports come in.
All right, thank you.
Any public comment?
Hello, Larry Bush again from Friends of Ethics. We'd like to say, first of all, that at our Friends of Ethics meeting the other day, people were thrilled at the completeness of this report. It's much better than anything we've seen in the past, and we certainly salute and applaud it. There are a few things that you might consider doing in the future. One is that the cutoff for 24-hour reporting is the day before the election. And our experience is that a lot of spending takes place on Election Day, particularly spending to get voters to the polls and phone banking and so forth. And that's not captured under the current reporting system until the report that comes in at the end of January, which is too long to wait. And I would suggest that you actually have reporting that goes for a full week after the election, because if you decide to take a look at when contributions come in, I think you'll see that the heaviest contributions come in at the end, particularly when races are highly competitive. That's my only thought on that.
Thank you. Any other public comment?
Commissioners, Ray Hartz, Director, San Francisco Open Government. What you saw last month was my reaction to the fact that when you ask legitimate questions, you get people who either sit in silence or make disparaging comments about what you're saying or who you are or what you're trying to achieve. I would not be so angry if I hadn't been doing this before this Ethics Commission for almost 8 years now. If I hadn't had 29 orders of determination from the task force, not one of which you've even bothered to do an honest investigation of. I asked a question the last time this item was on the agenda, and it was a realistic question. Who is this for? Yes, there's some nice information, and the only thing I've learned since then is from Mr. Bush just now, who said, oh, well, we got this, and we found it very useful. And I asked specifically, what's the purpose? Is this being sent out to all members of the public? Is it being posted in for the League of Women Voters? Is it, what is the purpose of this? Or is it simply a document that's presented here at the Ethics Commission with a dozen or so people who see it, and that's the end of it? Now, I agree. I agree with Mr. Bush. This is a lot of good information. But who is going to get it? And why is it such a burden to respond to a legitimate question relating to what is the purpose of it and what's the extension of its being sent out? What's its circulation? What is it hoping to achieve? I mean, doing it is one thing. But I would assume that the persons who are doing it had a purpose in doing it. And they also said, in part of that, determining that purpose, who they hope to approach, how they hope to affect them, whether they wanted them to vote, whether they wanted them to simply know the numbers, whether they wanted to give this information to people who monitor the Ethics Commission and the conduct of elections. And I don't think it's unreasonable to ask questions like that. But when you do, you get people who sit there in silence and act like you're asking some sort of an idiotic question. I taught for the University of Hawaii for 14 years, and the first thing I taught in every class was, if you have a question, ask it. I'll guarantee you two things. One, every question you ask, you're going to think, oh, maybe this is a stupid question and I'll look bad. but I'll guarantee you there are at least 3 or 4 or more people sitting there with the same question, because I stand up here and see them sigh with relief when you asked what they were afraid to ask. And second, ask questions, because the only stupid question is the one you don't ask because you never get an answer for it.
Thank you. Pelham, do you want to provide him with the information he's requested?
Yes, thank you, Chair Rennie. I'd be very happy to. The initial election update that we provided last month, as well as this one, were designed to help people understand and have some context for the election numbers that we're seeing. It's primarily designed to be a tool to help pique people's interests about the election, about campaign finance data, about third-party spending and other activities. And so to that end, we not only attached it to the agenda item, but when the reports were finalized, we also sent them through our interested persons. We pushed them out through our interested persons list. So the idea is that it will help drive people to go to our website, to go to our dashboards, look further into information, and to let them know that there is a place in the city where they can go to get objective, direct information about candidate expenditures and third-party spending and other spending in city elections. So it's an educational and informational tool.
Is there any contemplation that it will be put on the website so that the general public can pull it up if they want to?
And I need to confirm if it hasn't been already posted, but we are developing on our website, as we're getting ready to roll it out later this fall, the place where we will have this information that people can click on. So we may not have achieved that yet, but we have a lot of work to do to make sure we're getting a lot of information out publicly on our new website. So we'll check into that.
Any other public comment? Hearing none, we will go to agenda item number 5, which is discussion of enforcement program report. And again, I want to compliment Jessica for what I think is a very, very thorough discussion of the enforcement activities and where you're going and what you hope to accomplish in the future when you get some support.
Thank you, Chair. I wanted to start by just kind of giving an introduction. We put this report together in response to Commission interest at the September meeting for information about how the enforcement process works and what is happening with all of the matters that are in preliminary review or that have been advanced to formal complaints in our investigation. And I want to get to all of that in a moment, but first I wanted to provide you with an update on the Cava matter. And in September, you advised, or I guess moved, I think it was a motion, to have the staff send a letter to Mr. Cava about the electronic backup files for his calendar entries for July, August, and September 2015. I included the back and forth exchange I had with Mr. Cava on that subject, and the conclusion is that those files can be retrieved in the form, if they were in email form. So if someone sent an email to somebody about Mr. Cava's calendar, those emails can be retrieved, but the calendar entries themselves are lost when they were deleted. So with that behind us, I'll move on to the remainder of the enforcement report. We hope that this type of data will be something we hope to provide it to you for every commission meeting, so it will be an ongoing update, and you can hold us accountable for some of the things that we say we're going to do in here. As you know, when I started, Leanne had already undergone a pretty extensive programmatic and policy analysis of what needed to happen at the Commission in order to advance some of the goals that we all share, goals for fairness, transparency, and accountable enforcement of the laws, education and compliance, our advice responsibilities. And on that compliance plan are a number of provisions very relevant to my position, including a review of enforcement regulations and a review of all the other ordinances that the Commission enforces. So as an initial matter, Leanne and I reviewed that policy plan and made some decisions about priorities and where I should focus my time. My first thing that I did in conjunction with other staff members, including our current investigator, Catherine, was to review the current enforcement process. And she was an excellent teacher and helped me understand how it works quite well. I also reached out to Andrew to discuss it with him. And that's what I want to go over with you today because I think that would be helpful. Essentially, the charter is what governs enforcement as an initial matter. It has a lot of provisions and is fairly detailed about how investigations and enforcement are supposed to work at the staff level. You have adopted some regulations, the enforcement regulations. Those were first adopted, I believe, in 1997 and were amended periodically, but last in 2013. And those enforcement regulations are what appear to be the best attempt to sort of marry reality with how the charter expects enforcement to happen. So initially, I'll just say that when a complaint comes through the door, we consider that to be a matter under preliminary review, and we treat all complaints that are filed with us the same. We log them on a system and assign them a case number, and then contemplate what else needs to happen based on this complaint before we can move it along to a probable cause or an investigatory phase. The information about what's logged as complaints and what reaches the investigatory phase is already provided to you by Leanne on the monthly executive director report. That portion will be pulled out and placed into the enforcement report going forward. The complaint obligates us, however, we treat all complaints similarly. So even if it comes in verbally or in handwriting or via email, we treat them all the same as an initial matter. But we're obligated to investigate any complaint that comes in that's been sworn under oath, and that we have a reason to believe a violation of the law has occurred based on the allegations set forth in that complaint. So by that very definition, the complaint, if we're going to be obligated to investigate it, the complaint itself needs to be fairly robust. There needs to be a fair amount of information in there to credibly articulate what violation of law has occurred. I say that because a lot of our complaints are one-page documents or simple emails, sometimes verbal complaints, and we can't really do a lot about those things because there's not enough information there to substantiate what we can do. We can initiate complaints on our own, and we do that fairly frequently and are developing and have issued policy on how to do that as an internal matter. According to our regulations, to determine whether a violation of law has occurred, we're allowed to engage in what I mentioned before was a preliminary review. We can review relevant documents. We can informally interview a complainant. We can communicate with the respondent. And we can conduct any inquiry necessary to reach the conclusion that there has been a violation of the law or there hasn't, or at least that we have a reason to believe, a fair reason to believe that one exists. If after that preliminary review we think there doesn't appear to be a violation of the law, then we can dismiss that complaint. And we send summaries of those dismissals to you every month. If we believe that there has been a violation of law, if we have reason to believe that, we have to immediately send those complaints to the city attorney and the district attorney for their review. And then the city attorney and the district attorney get to decide whether or not their offices want to investigate the complaints also. They have to get back to us within 10 days with their decision. Their decision doesn't in any way impede our ability to continue with our investigation, however. There are circumstances where the district attorney has indicated that criminal investigation would take precedence over our investigation, and that would be to prevent any witness confusion or statement confusion in the two competing or dueling investigations. And whenever the district attorney has made that request, historically we have adhered to that request. So if a matter reaches the point where we're referring it to the city attorney and district attorney's office, we've got a reason to believe a violation of the law has occurred, we move forward with a formal investigation of the matter. And in this phase, we engage in what amounts to a full-blown investigation. We discuss the violations, we can subpoena records, we can look at everything that we need to in order to formulate the basis for a probable cause. We're aiming for probable cause because probable cause is the next stage in the investigatory process according to the charter. The enforcement regulations further govern that process by setting forth how probable cause reports are developed, what they need to contain, and how the commission needs to treat them. A probable cause report has to include a summary of the evidence and all the allegations against the respondent, and the respondent will have a right to counsel when that probable cause report is considered by the commission. The charter gives the commission the right to sit as a panel at the probable cause hearings, but it also says you can appoint an individual commissioner to serve as a probable cause hearing officer or hire an outside hearing officer. In practice, though, the Commission has historically sat as a panel for these probable cause hearings. If the Commission finds that there's been probable cause to believe a violation of the law has occurred, then you are to order an administrative hearing. And the administrative hearing is the full-blown hearing that we had with Lynette Sweet last month, where the court reporter comes and testimony is given under oath. Staff must issue an accusation, which is the equivalent of a complaint filed in trial court, against the respondent within 10 days of a finding of probable cause. Parties may engage in additional discovery, but as a practical matter, all of the investigation has already occurred because we needed to put together a probable cause report. Once again, the Commission sits as a panel to hear a hearing on the merits of an issue. However, you have the right in the charter to, again, appoint an individual commissioner to hear the matter and then issue findings of fact and conclusions of law for the full panel's consideration, or you can hire an outside hearing officer. In practice, though, you've sat as a panel. Now, one thing I have forgotten to mention until now is that the probable cause process, so from the complaint to the probable cause hearing conclusion, is all confidential under the Charter. The Charter states that all complaints are to be treated confidentially to the extent allowable by state law. Once probable cause has been issued and the accusation comes, from accusation forward, the remainder of the process is open to the public. So after this review and with this understanding, I identified some areas where we could use improvement in terms of the process and in terms of our resources. So I'll start with some resources that we need to improve our process. You know, we completely and fully understand and do not back away from any allegations that we have too many matters in preliminary review. We have too many matters that are still in investigation, and it takes a long time for those matters to be investigated. We know that it's taking too long. So with an eye toward improving that efficiency and improving that process, we've been working internally to identify those problem areas. The first that we've identified, which Leanne has already gotten started before I even came on board, is a staffing issue. Historically, the Commission has enjoyed, really, 4 investigators, all working full-time to review matters that come in the door and to investigate those matters and bring them to the Commission for final hearing. Starting in 2008, we lost investigators and were unable to replace them due to budget considerations. So in 2008, we went from 4 to 3 investigators. In 2011, we were down to 2. And in May of this year, we now only have 1 investigator. Leanne has been working diligently to fill those positions, and we are hoping that we will be able to post them 2 of them at least very soon. That's an obvious first solution. But what have we been doing in the interim, and what can we keep doing until they're filled? Obviously, from posting to fulfillment can take some time, so it might not be until winter before we have our full group back working on these matters. So at the interim, our investigator has been working diligently to work through the preliminary review caseload. We actually met with Andrew recently in order to help get some manpower on the subject and issue spot and bad ideas around about where we could identify matters that needed to be investigated. She's been doing a great job of going through and dismissing right away matters where we lack jurisdiction, because we don't want the public to think that they have something with us when they don't, because we don't have jurisdiction. And we also have been contemplating and theorizing how best to do an education campaign for when we are fully staffed and we can alert the public how our jurisdiction, our authority relates to their daily lives and what they're seeing in their public officials and in their government employees. We've also been working to develop collaborative partnerships. I mentioned that we've been working with the City Attorney's Office on some review of preliminary matters. We also all traveled to Sacramento in September to meet with the FPPC, do some research and introductions to sort of open up doors for joint investigations with the FPPC. And we're reviewing our internal enforcement process to determine where we can shorten time spent on each step as an internal matter. And we also met with the district attorneys and city attorneys separately to discuss what matters they're retaining and what we can do to do a better job to get them the information that they need in order to conduct the investigations that they need. You know that we are also undertaking, according to the annual policy plan, a review of those regulations for recommendations for amendments and approvals. I've set forth a detailed policy or a detailed plan for how we're going to go through that process at page, I think, 6 of the enforcement report, in case you want to see it in detail. I will say it as an initial matter that 10-day turnaround from probable cause finding to accusation is something that I have pinpointed as either needing to be expanded or rethought, so that all the investigation isn't being undertaken pre-probable cause, so that we can get matters to you for a probable cause finding earlier and then go on with discovery in the context of litigation quicker. We're also looking at improving efficiencies in the regulations. Finally, I have been working with Leanne and others to identify areas where we need to really hone in on how we prioritize our work. And I think this is probably one of the more important areas, because we can do all the regulation and ordinance changes that we want to, but if we aren't really having a discussion about internally and how we can change our processes, then we're failing. So as you know, we have 3 areas of original jurisdiction: governmental ethics laws, and then where the mayor's office would file charges before the commission for official misconduct, and then whistleblower and sunshine ordinance matters. As a practical matter, we've only had 2 of the mayor's office charges ever filed before the commission in its history. So we don't really spend a ton of time on that. That's not a time management issue. The vast majority of our complaints come under the umbrella of governmental ethics, the campaign finance, the conflict of interest code violations. And then we get a minority of, and a substantial minority, a not insignificant minority of complaints coming as a result of our authority under the whistleblower ordinance and the sunshine ordinance. And I want to talk about those 2 specifically because they're fairly time consuming, and our attention is required of those immediately because of the way the laws are written. So the whistleblower ordinance gives us authority to investigate complaints filed with our office and filed with the controller's office involving allegations of laws under our jurisdiction. So that'd be campaign finance, lobbying, conflict of interest, etc. They also give us jurisdiction to investigate any retaliation complaint that's filed with our office, any retaliation complaint. And that's where it gets a little bit tricky, because we currently don't have any expertise in some of the areas where we are being asked to investigate claims of retaliation. It's usually very complicated and complex personnel matters where we're dealing with claims of retaliation. So it takes a lot of time to get to know that department, to get to know the people involved, to understand all of the processes in place for that department in terms of employee rights and employer responsibilities before we can even reach the point of probable cause. And so that, as a practical matter, takes a great deal of time, but we also want to treat it with the sensitivity and care it deserves, because this is people's careers and lives. The other area where we have authority and people can file complaints with us is under the sunshine ordinance. As you know from last month, we have authority over willful violations of the sunshine ordinance by elected officials and department heads, and then we have authority over referrals from the task force. We have authority in a couple of other ways, but those are the main categories of information. The fact that we can initiate our own complaints via or handle the referrals from the task force, though, leads people to believe they can file their original complaints with the Ethics Commission. So that means that we're getting people who've not gone to the task force, people who've not reached out to any other agency for enforcement, filing complaints with us for violations of the sunshine ordinance. So what does that mean for us? It means that we're spending a great deal of time looking at stacks of records to determine whether or not information was properly redacted. We're spending time interviewing public information officers to see if deadlines were complied with and whether the nuts and bolts of the sunshine ordinance provisions were met. We're not sure that the law requires us to do that, and it might be a fix that we can do within the regulations or within some policy change. But as a practical matter, it's what's happening, and we are respectful of the people who are filing those complaints with us and trying to do our best job. Now, the sunshine ordinance itself requires us to have an answer for people very quickly, and we're required to update them constantly. I think it's like every 10 days or 14 days we have to update people about our progress. But we're also required to put it on your commission agenda for the very next meeting, which means that we have to investigate and prepare for a commission meeting on a sunshine ordinance complaint as quickly as possible. As a practical matter, that means we're dropping everything else. Right? We're ignoring other ongoing investigations and other complaints that are coming in order to handle the sunshine ordinance matters. So long-term solutions, we're evaluating the laws. Commissioner Kopp rightly pointed to some areas that that should be considered for revision at the last meeting, but we were already undergoing an analysis of the sunshine ordinance and the regulations to determine were there any other areas where we could improve the process, improve efficiencies. I've outlined a plan for how to do that on page 9 or page 8, I think, of the enforcement report. So finally, I wanted to talk to you about just our plan for going forward. Once again, I want to, this is all planned for going forward, but our immediate attempts at triaging and fixing the processes that are going on right now. And let me turn to my page of my report where I handle that. As you know, we've attached the data that you like to see every month. We currently have 84 matters in preliminary review. I'd like to put some context to that number for you. It's in April of this year, right before we left, our second investigator left. Only 43 matters were in preliminary review. So our matters in preliminary review, the matters we've been unable to get to, has doubled since we lost our investigator. There was a period in there where we didn't have an executive director who could approve dismissals, and so the matters backed up as well. We've also had we've been sort of reorganizing and restructuring the office because for a number of reasons, but within the enforcement program particularly, our investigators used to also manage compliance tasks for certain programs, and so they were in the advice and reminder giving business and the intake of form business on entire programs rather than doing investigations exclusively. So now hopefully we're going to be transitioning them to doing investigations and enforcement 100% of the time. I also want to just statistically, in October of this year, of the 84 matters that are in preliminary review, 74% of those are less than 6 months old. But in April, only 56% of those were less than six months old. So we've been seeing, we've got a lot of complaints coming in because it's the election season. And we are dealing with those as quickly as we can with the staffing levels that we're faced with. So going forward, our immediate priority is to deal with that backload. Obviously, we're taking on these ongoing programmatic and regulatory reviews processes very seriously, and we'll have reports for you on that process as we go forward. But we're also going to be, we have been prioritizing the complaints as follows. Number one is elections related complaints. If the matter has to do with, if the complaint has to do with a matter that's happening right now that has a real-time impact on this election, we're treating it with priority. Our second priority has to be sunshine ordinance and whistleblower investigations because of the way the laws are written on those subjects. And then our third priority is to go through the oldest matters in preliminary review and the oldest open investigations as quickly as we can. So we're working toward that now. So with that, I will conclude and take questions if you have them.
Anyone have any? Mr. Kopp?
Yes. I appreciate the fact that complaints and the resultant complaint log, which is provided to commissioners as confidential, is required by charter provisions. So I don't know how far I can go publicly asking questions, but I think you said there are 84 pending complaints, or did I mishear?
That's correct. There are 84 matters in preliminary review, which means that we have
under preliminary review,
right,
not reflected in the law.
Oh, right, the log. Yes.
Yeah.
I think
because all I know is the log.
Right. You've got the log,
Okay.
which is about 23, I think, right?
Now, one area your report didn't seem to cover was something I mentioned in passing, but I'll reiterate now, is the number of complaints which have investigations stopped because the DA says don't investigate further. On the premise the DA will handle this. And without conveying any complaint log specifics, there are a lot of those. Have you considered whether there should be a time limit on suspending investigation after a honored request from the district attorney to cease investigation?
Yeah, so I like you, found that to be odd when I started and conducted my initial review. And so what we did was we met with the district attorney's office. And I can't recall how many matters were suspended by the district attorney at that time, but it was a lot. And we went through the list of matters that were suspended at their request. They explained to us that the reason why they were asking us to suspend our investigation was because they didn't want to have dueling investigations while they were investigating a criminal matter.
That's always the claim of a prosecutor.
I agree.
Always the claim, whether it's a legislative body or an administrative body.
Mm-hmm. We pushed them.
Count me as a skeptic.
I might be in your camp. So we pushed the district attorney's representatives there to lift the bans on and to let us go forward with investigations more frequently and more openly. We even proposed joint investigations where we would both engage in investigations together so that there wouldn't be dueling interviews. They were for that in some instances and against it in others, and they had some compelling reasons that we can discuss perhaps more privately because it'd probably go.
All right. Is this allowable as a closed meeting issue discussion?
Yes.
It is.
Yes. In the future, if you want to discuss particularly.
Well, Mr. Chairman, I would like that to occur.
On the November calendar.
Huh?
We can put it on the November agenda.
Please.
Okay.
Okay. And so there's no resolution as far as an agreement with the DA and a time limit.
We did actually reach a resolution. The DA has agreed that unless the matter involves complex or complicated additional crimes, like some of the things that they have kept are for matters where the FBI is involved. In the absence of that level of complexity, we are going to be allowed to proceed with our investigation either simultaneously or upon the filing of charging documents.
Upon the what?
The filing of charging documents by the DA.
Well, but no particular limit like 90 days.
No.
We suspend, and if you don't do anything in 90 days, we resume.
I think that's true. I think that you'll see a decrease in the number of matters that are suspended, however.
Well, I'd also like that enforceable with a time limit. And I invite your advice and suggestions and recommendations on what would be appropriate.
Okay.
And then finally, is there a generic reason why, for example, an item would be returned to us by the district attorney, and then it just lingers for a year plus or minus?
There's no specific reason for that. It's just the overarching issues that I identified previously, and we are working very diligently to try and get to those matters as quickly as possible.
And the objective is to clean up the list.
Well, it's to get justice, right? It's to enforce the law. That's the objective. We don't like having people be brought before the commission multiple years after their election campaign or after the violations were committed. It doesn't help with deterrence. It doesn't help with the purpose of enforcement. It doesn't help with our ability to get penalties. So we would like everything to be shortened. We'd like to get matters resolved much more quickly than they have been able to be in the past.
Thank you, Mr. Chairman.
And
You mentioned undertaking an educational campaign for the public, presumably. Could you talk about that a little bit? What would be the overarching reason, and how would you go about it? I mean, what you're talking about for the average individual, the average citizen, is very complicated. And one of the problems that I at least have perceived is that people still don't really understand what the jurisdiction of the Ethics Commission is, to put it mildly. And then they expect, when they bring something to you, they expect it to be resolved very quickly without understanding all of the complexities that you've just outlined. And there are so many areas that would seem to fall under the Ethics Commission, but really where we have no jurisdiction or power to deal with. So, I mean, I would hope that that would be part of the educational campaign, although I'm sure it's more complicated than one might think in trying to educate the public on that.
Yes, absolutely. Educating the public about our jurisdiction and how the enforcement process works and how to file and where to file a quality complaint are at the top of my list for subject matter in an education campaign. We're starting with a very significant revision of our website, which, you know, we can't put everything on the website, but we're doing a complete overhaul in order to better direct individuals who traffic our website to the areas of inquiry where they came and why they came to the website. In my view, in my vision of this educational campaign, the goals would be to increase the public's understanding of what we are authorized to do and also what we can do to help them, and to sort of instruct them on how to file quality complaints with us that we can investigate and handle. How that looks and how that shakes out is still in the very beginning stages. It's just something that we've been discussing internally right now, but it's definitely something I think that's on my radar. When I say it, everybody kind of has a little bit of a heart attack because we're not sure we're ready for an increase or significant increase in the filing of complaints right now. And that's right. That's absolutely right. If tomorrow we got 100 complaints, you know, that would be difficult for us to deal with. But in the future, getting 100 complaints is not something that I would want to shy away from. It's something we would want to encourage.
But particularly in the area of whistleblower complaints, which have come to us, and when there's a lot of discussion about who really holds jurisdiction, whether or not it should come to us or if it's really HR. I mean, I think a lot of those complaints are much more human resource.
Absolutely, yeah.
And they have more jurisdiction than we do, and I think there's a lot of misunderstanding about that. And then I think also the redundancy, or so it seems to me, of the Sunshine Ordinance Task Force and the complaints that they then filter to us, and which are often dismissed for any variety of reasons. But it does seem as if there's redundancy there, and I don't know. I know that we've worked with the Sunshine Ordinance Task Force in the past to try and resolve issues and misunderstandings between the Commission and the task force, but it seems to me that there's still a lot of work that needs to be done in that area. So I don't know if you see it that way, but perhaps.
No, I absolutely do. And I think at the November Commission meeting, we're going to try and have several Sunshine Ordinance matters on the agenda. Or is it? No, it's December. November. One of the upcoming Commission meetings. I think Catherine's not available in November, so it might be December. We're going to have a number of Sunshine Ordinance matters on the agenda for you to consider, with a memo for a proposal for how to deal with those matters and to deal with the conflict between us and the Sunshine Ordinance Task Force. And essentially, I'll be honest with you, my leaning is to be more deferential to their findings and to not undertake our own independent investigation of every matter that comes in the door, but to view ourselves as an enforcement authority when they do refer a matter to us.
Any other, Mr. Keene?
I just like your thoughts on one aspect of our process that you took us through quite nicely in terms of where from a complaint through to the determination of the complaint, and that is the probable cause hearings. In regard to the probable cause hearings that we had, we have one of the things that this commission has always put forth, that we want as much transparency as possible. Public should know exactly what we're doing, so that they can have respect for it and see that we're doing it legitimately. The probable cause hearings that we have we hold them in closed session. I come from a background of having been a criminal defense attorney and a public defender for many years, for 30 years or so, in which you give the ultimate due process to the person who is charged, because you're taking away that person's life and freedom.
Mm-hmm.
And the probable cause hearing in the criminal justice system, which is a preliminary hearing, is open. Public sees it. Public sees what's going on and can make decisions in regard to a very, very important part of the process of prosecution. Why is it that our proceedings, where due process in terms of what's at stake, no one's life is freedom is at stake, at worst what is at stake is that there's some sort of ethical type of sanction, maybe a fine, whatever. Why is it that, if your view, do we have to give that level of due process to someone to whom a complaint has been addressed in an ethics situation, and have a closed probable cause hearing? Why couldn't we do it in the open like we do preliminary hearings in criminal cases?
Mm-hmm. I agree with you. I think it's odd that it would be closed, but that's the way that our charter has laid out the process. So we're kind of stuck with that aspect of the issue. Where we could improve the process, though, for the commission and for the public, is by not having the full panel sit for the probable cause hearing, but by assigning either a single commissioner or an outside administrative law judge to handle the probable cause hearing confidentially and quickly, so that the full panel of the commission doesn't have to sit twice, because essentially you're hearing the same evidence twice at both probable cause and the hearing on the merits. That level of due process is certainly not required by the charter, but is currently being given.
So in terms of remedying what we both think should be remedied, the answer is a charter change.
Yeah.
Correct. Okay.
Oh, yeah, sorry. That would be the answer to that. Yep.
Thank you.
Anyone else?
Mr. Chairman, let the record show I want to associate myself with Commissioner Keene's remarks. I had occasion about a year and a half, maybe 2 years ago, where somebody calls me to tell me a long story problem with the Ethics Commission, and referred to this confidential meeting with the Commission, and I was skeptical. I said, no, that can't be the law, but it is the law.
So I would just like to encourage staff, when you come back with recommendations either at the November or December meeting, to think of the best, in your best judgment, what would be the most effective ways to make the process more efficient and more effective, both for the staff and also for the complainants going forward. And if that means, to Commissioner Keene's point, to going back and revising the charter, then we'd like to consider that as well, I think.
Yeah, and absolutely. That November, December for that kind of discussion is a little soon, because we want to engage the public. Mm-hmm. The process that I've formulated and with Leanne's, obviously, Leanne and I have formulated, I'm not doing this on my own, is to first start with a series of interested person meetings with the public, and to do those publicly and openly and engage the public in their ideas and their thoughts on how to change the enforcement process so that it works better for everybody. Then put pen to paper based on those, after pooling all of those recommendations and ideas, to come up with the suggested changes to the regulations. And if ordinance or charter changes are necessary, then to put those in like a separate box that we need to consider before the commission. But the regulations are what the commission can deal with now. Once we have those suggested recommendations, we'll bring those to the commission to review and then open up a period of public comment for 30 days so that we can take written public comment on the actual draft language of the regulations. At the conclusion of the public comment period, we would take another 30 days to incorporate and respond to those comments and then bring the full package of suggested recommendations back to the commission. We just want the process to be as open and and involve the public as much as possible.
One more comment. So you noted earlier in your comments and also in your memo that if there's a sunshine ordinance or a whistleblower complaint that comes in, it must take priority over all other complaints because it needs to be presented at the next commission meeting. So I take that to mean that if it came in a week before the commission meeting, you'd have to scramble to conduct that, all of the background work to be able to present it to us at the next meeting. Is that correct?
Well, the regulations give us a little breathing room in those circumstances, and it says where appropriate or where possible, because there are notice deadlines that we have to give the other parties. So if it were a week before this commission meeting, it would be the next appropriate commission meeting. So in this case, November.
So I guess my concern would be, and without diminishing the importance of those complaints that come in under the Sunshine Ordinance or the whistleblower ordinances, what is of concern is that everything else will get pushed to the back burner, and that I think it would contribute also to the backlog. And so I'd love your best thinking in terms of how best to balance those competing priorities.
Absolutely.
Isn't it correct, Ms. Pelham, that in Los Angeles, the process was that you as the executive director did the probable cause determination, and it was only after you made a determination that there was probable cause that it then went to the commission for a hearing on the merits?
Yes, under the Los Angeles Charter, the probable cause process was, again, confidential, as it is here, unless waived by the respondent. And so the probable cause determination hearings were held at the staff level. They were confidential. And then based on that process, there was a 30-day time period for issuing a probable cause determination, which was written. It came out under my analysis and my signature. There were over 400 cases during my tenure as executive director there. And then if probable cause was determined, was found, then an accusation was issued publicly according to the rules, and then it went to the Ethics Commission for a public hearing, a hearing on the merits at that point.
So that, as you understand the charter, is there any reason why we can't go that way without a charter change?
I'd have to take a closer look at our charter here. I think the two issues that have been raised in your discussion is the degree of confidentiality that the Commission desires for that process, and then separately the notion of two bites at the same panel, in essence. Is there a way to separate out the due process so that there is one step for a probable cause process and then a separate process, an independent process for hearing on the merits?
It would seem like that is more consistent with due process than to have the body who's going to be making the determination as to whether there's a violation be the one that also looks at the evidence without any public knowledge and makes a determination.
I think that's a proposal that would be very helpful to take a really close look at. I think that's something worthy of our focus and discussion.
All right. Any other comment by the Commission? All right. Any public comment?
I just have one question. On this log, all those kinds of items can only be dismissed by the Commission. Is that accurate? No. the executive director can dismiss those items as well as the preliminary review.
Under the example in Los Angeles that I was describing, the executive director had authority to determine whether or not probable cause standard was met.
Now, does the commission
No.
have to? Got 84. You reported preliminary review. You've got a log you gave us that's confidential. Items on that log. Who can dismiss those? Only the commission?
Yes, only the commission.
That's my question. Okay. Thank you.
Bush?
Thank you, Larry Bush. Speaking as an individual, the civil grand jury report on ethics that we put out in June of 2014 looked at a number of these issues. And as you have just discussed, we quickly learned that when we focused only on the Ethics Commission, we did not have a very complete picture. We had to look as well as on the city attorney and the district attorney and all the other arms of government that are involved in ethics policy and enforcement. One of the things that I did separately when I was doing city report was put in a request to the district attorney and the city attorney and ethics for how many cases had been referred from ethics over to the city attorney and to the district attorney. Just the number, and you couldn't get the actual cases. And what I discovered was that the district attorney had no record of any referrals. They just simply were not keeping track of them. I assume that they had referrals because there was some indication that ethics had sent things over, but they just disappeared. So earlier I heard the commissioners discussing the fact that these referrals went to other agencies but then did not come back to the Ethics Commission. And I believe it was Commissioner Keene who raised the point of couldn't there be a deadline at which point the commission can either take it back or else do a parallel investigation. And I think that that's something that's certainly worth consideration, especially since you have a more robust approach with staff now. Thank you.
Thank you.
I've got 90 days in mind.
Commissioners Ray Hartz, Director, San Francisco Open Government. First, I would like to say I've been coming to these hearings for about 8 years. I'm a member of Mensa, and I read all of the documents that are attached to the agenda, every page, every word, sometimes several times because it's hard to understand. And I would like to compliment Ms. Blum. Is it Blum? Yes. Okay. This is the most coherent, cogent, understandable, comprehensive document that I have ever read presented to this Ethics Commission. I would also like to compliment her on the fact that the Sunshine Ordinance got a full page, which is something that typically never happens. It would get 2 or 3 lines while everything else got very thorough treatment. I particularly was amazed and heartened by the fact that her public comment was the fact that she said we ought to give more deference to the findings of the Sunshine Ordinance Task Force. And the reason I say that is, as I've said before, I've got 27 orders of determination. But that's over 9 years, is about 3 a year. And every one of those years, there were 30 or 40 orders issued by the task force. And not one of them in all these years has ever been enforced. Only one was even attempted to be enforced. So it's all well and good to keep looking at the procedures and the policies, et cetera. But if if push comes to shove and you make findings and you can't enforce them, it's really kind of a useless effort. The only one that ever went was the president of the Library Commission. They watched a video of her, the actual event. They voted unanimously that she had violated the rights of a member of the public to make public comment. They recommended to the mayor unanimously that she be removed for conduct unbecoming, and the mayor ignored it. A year later, and it was in the newspaper, we got them to send another letter, and the mayor ignored that. So basically, unless you can find some mechanism to enforce your orders, it's really kind of odd to have the hearings in the first place. And I've said it before, and I've said it in sarcastic ways because I didn't know how to get across to people. But if you're going to have hearings and make determinations, but you can't enforce them, that just hurts your own credibility. And that's something I tried to say politely for several years, and just got so frustrated and angry by the fact that everybody seemed to think I was just, coming out of the left field with some bizarre notion. The task force works very hard, and they hear a lot. They hear a lot of hearings, and they issue orders of determination, probably about 1 out of 10 cases. But when they do it, they honestly do a very good job at doing the facts, and the chairs usually write very, very good referral letters, and I give them credit for that.
Thank you.
Dr. Derek Kerr, a whistleblower. It's not enough to talk about resources and regulations in improving investigations, particularly of whistleblower claims. You also have to address a political milieu, a mindset that affects the staff and the commission. Whistleblowers represent a threat because they break ranks with the city family. And you are part of the city family. You know many of these officials. You empathize with them. You're affiliated with them. So it's scary, or it induces some fears when you have to deal with an accusation of wrongdoing by a fellow city official. Particularly for the staff, they have to worry about what will happen to them if they find in favor of a whistleblower. And this is a problem in all whistleblower programs, not just here. So I hope that the staff will address implicit bias against whistleblowers and fear for their own careers if they pursue a case. These are real things, and you really should address them. Thank you very much.
Thank you.
I wanted to say that in my 19 years, almost 20 years following ethics meetings, this has been the most robust discussion we've had on the enforcement program. And I see light bulbs going off all over the room on how we can get ourselves in a much better position to represent the public interest, because I think we have not been. And there is a growing period as bodies like this are formed. It takes about 10 years to get underway. We're now over 20, and we're still finding our way. But I want to just say to the new commissioner particularly that the shocker to me is the fact that our deputy director who just did our analysis has just only been here 6 weeks? 2 months. And I am personally awed. So her training and intelligence is becoming. I did want to ask a question, and that is on staff appointments. When do you see those appointments coming for the 2 new investigators? Roughly what time frame? I know you're talking about advertising. But I'm concerned, too, that one of the propositions on the ballot may actually fail, and the city may not have revenue, and consequently there may be a freezing of hiring. And that could occur, obviously, within a couple of weeks or within the month after the mayor sees the results of the election.
Thank you. Want to answer his question?
Yes, we have 2 positions that we're hoping to post this week, the 2 senior investigator legal analyst positions. They are both civil service positions, and that process is fairly lengthy. So I would assume, if all goes well, we would hope to have somebody on board at the end of the calendar year, most likely beginning of January.
Thank you. Right. Turning to agenda item 6, the Executive Director's Report. Ms. Pelham.
That was a good teeing up for the Executive Director's Report. I wanted to take a moment today just to introduce to you our Executive Fellow who joined us from the Fuse Corps program out of the Mayor's office. Gayatri Taikandil is our new executive fellow, and I've asked her just to introduce herself for a moment. She is working with us on many of the topics on the front of your mind, making sure that we are using technology in the smartest way possible to help provide compliance assistance and guidance. But I wanted to just take a moment to introduce her to you.
Good afternoon. My name is Gayatri Taikandil. As Leanne mentioned, I'm the Executive Fellow with the Ethics Commission. I'm very excited to be here and meet everybody in person. Just to say a little bit about myself, my background is in software development and technology operations. I worked in the private sector for over 10 years. I'll be working with the Ethics Commission staff to look for ways to gather, organize, and disseminate information on our website and other channels to make it easier for the public to find and use. Right now, I'm focused on really learning about the responsibilities and the functions and systems within the organization. In the upcoming weeks, I'll be working with the team closely to identify areas where I can help with. And I'm also looking forward to working with all of the stakeholders at large in the upcoming year to really work on these efforts. So I'm really glad to be here. Thank you.
Thank you and welcome.
Welcome. Thank you.
I'm sure you look forward to having one-on-one conversations with her as time goes forward, as well as to others who are very much involved in the work of the Commission. And just one last note, but an important one. We do have 2 positions currently under recruitment. They are posted at the City and County Jobs page on the Department of Human Resources website for a senior policy analyst and for an education and compliance management assistant. Both of those positions are exempt, and the deadlines are coming up by the first week of November. So we've encouraged folks. We've gotten the word out broadly, and we're hoping to move that process along a bit more expeditiously. So I look forward to keeping you informed about that process. Happy to take any questions if you have them.
Anyone have any questions? Public comment?
One quick question. So that is 2 investigators, an educational specialist or outreach information, policy. Oh no, there's a policy analyst, but then there's an educator.
The senior policy analyst and policy analyst are both going to have a role in doing education as well as running programs.
I see. So that's 4 positions you're hoping to hire by the end of the year.
Yes, I am hoping to hire by the end of the year.
I'm as awed as I was with your executive director's report, deputy executive director's report. Thank you.
Any other public comment?
Good afternoon, Commissioners, members of the public. My name is Starchild. I'm Outreach Director of the Libertarian Party of San Francisco. I came to speak on another matter, but I had some tangential questions for the Executive Director. But I also wanted to know when is the time to raise issues not specifically on the agenda. I noticed a copy of my letter to the Commission was here provided for the public. However, I did want to point out that letter is apparently missing a page. There's part of the letter and the cover letter, but the other is missing, at least from the copy that I picked up. Also go by just Starchild, not Mr. Starchild, but that's a minor point.
If you want to bring up a matter that's not on the agenda, the last item on the calendar gives you an opportunity to do it. You could have done it at the very beginning.
Understood.
But when we reach the last one, I will call for public comment of items either on or not on it.
All right, thank you. I did have a couple questions for the Executive Director, though. When I filed my complaint, I wasn't told by staff what the procedure was to get something placed on the agenda. And as a result, I made the request apparently too late for the item to be placed on the agenda for this meeting. I'm just wondering what the protocols are there for staff to inform members of the public, whistleblowers to bring forward complaints about their rights and opportunities under the law to have their information presented.
Well, as a matter of course, if there is a matter that comes to us that is a complaint, it is not something that we handle on a commission's agenda until such time that it either comes to, as we were discussing in the last item, as a probable cause matter or a hearing on the merits. So simply by filing a complaint with the Ethics Commission, that does not place it on a public agenda for the Commission. If we are provided with information that we do not understand to be a complaint, but to be a point of information, again, then that's something that we would take under advisement, look to see if there is a need to pursue an investigation. But as a matter of course, information brought to us is not automatically placed on the Commission's agenda.
Yeah, I guess my concern would be with that process, the members of the public like myself who aren't familiar with the proceedings, what I was bringing forward in my mind was a complaint, but I wasn't told that it had to be worded in some specific fashion in order to be recognized as such. Also, when I first dropped off a hard copy under the door of the Ethics Commission office, because by the time I got over there from City Hall, after having to go through the security to get into City Hall, go around the side of the building with a backpack, they keep getting more and more adverse to the Fourth Amendment around here. But by the time I got over there, your office was closed. I put the letter under the door, hard copy, but when I followed up by phone a day or two later, I was told that they never received it, that perhaps the janitor might have thrown it out, which kind of was disturbing to me. Things that are placed in there that clearly copied to the Ethics Commission, might not be reaching the Commission, depending how they're delivered. But at no time during the follow-up conversation, I was also called back by lady on your staff. I don't recall her name immediately, but I wasn't told of the procedures to get something put on the agenda, or that had to be worded in a certain fashion in order to be recognized as a complaint and to start the wheels in motion.
That I don't think it's germane to the subject matter of this particular report, and we will take it up at the end of the meeting.
Okay. I guess my understanding was that when an official like the executive director gives a report, then it's proper, germane, to ask her questions, even if it wasn't in the specific subject of the report, if it's something that falls under her job duties. Would that be incorrect?
I'm just happy to answer the question in terms of your concern about whether information gets to the staff and whether we're giving information to the public correctly about the process. We're happy to take that feedback and make sure that we've got all of our information straight in the office so that there isn't a confusion about our process. We certainly wouldn't want that to happen.
Thank you. Yeah, that would be helpful.
Yeah, thank you.
And also I'd request that the full copy of my letter and the attached photograph, which also wasn't included in this, provided to the public, be provided to the public and be put in the record for the proceedings and made available in hard copy at the next Ethics Commission meeting.
Thank you.
Thank you.
I'll take a 10-minute recess before we go to item number 7, coming back at 3:15. Oh, I'm sorry. Yeah.
Commissioners, Ray Hartz, Director, San Francisco Open Government. When President Clinton, I'm getting ahead of myself, when Secretary of State Clinton took her job, she wanted to do a reset with Russia. And that was at the direction of the President Obama. And I would like to take this opportunity to propose a reset with the Ethics Commission. I've been coming here for 8.5 years now. The treatment I have received and watched other members of the public receive was, I thought, beyond the pale in many cases. And after a while, when you ask questions and get no responses, or if you get a response, it's a denigrating or insulting or demeaning response, you have a tendency to kind of look askance at everything. The executive director obviously hired Ms. Blum, and you've heard several members of the public give her, plaudits for her performance in this particular issue. You heard another member of the public say that the last meeting and this meeting are the first serious discussions that he had ever heard in his time coming to the Ethics Commission regarding some of these issues like open government and transparency. So obviously there is a movement in the right direction, and I would like to take this opportunity to say, please understand that my prior comments were in some cases very well tempered by the years of bad actions. Now, given that, I would like to say that I still was very concerned about the fact that I put in 2 complaints under the Sunshine Ordinance, and both of those I was denied a hearing. And one of the things that the Sunshine Ordinance requires, it basically says in 6734 that a willful violation is any duty that a member of the public, an elected official, and so forth fails to do, which is their responsibility under the law, is a misdemeanor. And in the case of Mark Farrell, which you've refused me a hearing, Supervisor Farrell refused to answer an IDR. He got a complaint, refused to acknowledge the complaint. They had a hearing. He refused to send anybody to the hearing. They issued an order of determination. He refused to answer the order of determination. And finally, when it went to compliance and amendments, he sent a very terse memo saying, we have no responsive documents. And that was 9 months after the IDR. Now, when a public official so blatantly violates their responsibilities under the law, I think it's something worth this body hearing. And I'm still upset by the fact that it was denied a hearing.
Thank you. We now take a break till approximately 3:16.
Thank you, Mr. Chairman. And it counts, huh?
SF Gov TV, San Francisco Government Television. SF Gov TV, San Francisco Government Television.
Commission consideration in Mark Farrell for District 2 Supervisor 2010 et al. Versus City and County of San Francisco for payment for a $25,000 payment by Supervisor Farrell and mutual release of legal claims. Ms. Eisenberg, you've been working on this matter. Do you want to bring up just where the matter stands for the Commission's consideration, and then we will go to the question of a closed session for some further elaboration from you.
Sure. So since this matter was last before the Commission, there has been a number of developments that I wanted to discuss very briefly. First, Supervisor Farrell actually filed a lawsuit against the city seeking a court declaration that the forfeiture demand was improper. The city filed a countersuit seeking a declaration that it was proper and seeking forfeiture of the amount. After the city filed its lawsuit, Supervisor Farrell filed what's known as an anti-SLAPP suit, arguing that our case arises out of protected First Amendment activity. And the law says that if a case arises out of protected First Amendment activity, then the plaintiff must show a likelihood of success on the merits at the very early stages of the litigation. And so Supervisor Farrell argued that because this arose out of his protected activity in his campaign, we had to show that likelihood of success, and were unable to do so because the 4-year statute of limitations on such actions had already run. We filed an opposition to that motion. Our first argument in that opposition was that this anti-SLAPP motion does not apply to our case because when the city brings an action as a public prosecutor, the anti-SLAPP motion is inapplicable. Unfortunately, after we fully briefed the case and shortly before the case was first scheduled to be heard by the court, the California Supreme Court ruled that the anti-SLAPP statute does apply in such circumstances. If we lose that anti-SLAPP motion, the result of that would be that our case would be dismissed and the city could potentially be required to pay Supervisor Farrell's attorney's fees. Accordingly, and simultaneously to working on the briefing and the litigation in this regard, and at the Commission's request, we continued working to see if there was an avenue to resolve the matter out of court. Working at the Chair's direction and with Chair Rennie, and following many hours of discussions with Supervisor Farrell's counsel, we have a proposed settlement agreement to resolve this matter. We have previously advised all of you about the issues and the potential risks of this case, and ultimately it is your decision whether to settle, but this settlement represents the best settlement that we could negotiate on behalf of the city in light of the circumstances and the issues that we have addressed with you in the past. If this case does not settle, the anti-SLAPP motion is currently scheduled to be heard by the court on November 3rd. We are prepared to litigate that, but as I mentioned, if that motion is unsuccessful on our side, then our case will be over and we will be at risk of being charged with attorney's fees. We are prepared today to give additional guidance and analysis on the settlement agreement and the legal issues presented by the case that we have previously discussed with you in closed session today.
Do I hear a motion that we go to closed session? I'll second.
Let me ask a question. All right. In other words, we one way or the other will take public comment, correct?
Absolutely.
Okay.
And one way or the other, we may, during, if we go into a closed session, agree to reveal everything that we've done in closed session. That's one of our options as well, and get into discussion relating to it.
I'd support that. Okay.
Right. Any public comment on our decision to go into closed session?
Members of the Ethics Commission, Ray Hartz, Director, San Francisco Open Government. This has dragged on for literally years. And I think this is the first time that we've heard anything of substance about where this case is at this point. I understand the logic. In fact, I was just mentioning that to someone, another member of the public, in the fact that they're probably, if you lose the case, then the city's going to be sought for the attorney fees, which is, better than what you can get. And I want to compliment Commissioner Keene in the fact that this is the first time during all the discussions that have been held in this manner that any sort of an indication has been given to the public that they would get some information about how we reached this point. And I think that's one of the most frustrating things for the public is you see these things going on, and with much going on in the government right now, the government really isn't trusted by a lot of people. Unfortunately, Donald Trump, I think, is getting as many votes as he's getting simply because people would rather deal with anything rather than what they presently have. So I would encourage, I understand the legal necessity for going into closed session, but I also want to say that I believe, and I may be wrong, and maybe your explanations after, if there are any, it will do that. But I really do believe that this all will probably in the end come down to the responsibility of the former executive director, Mr. John St. Croix, whose direction of the Ethics Commission staff literally for years seemed to be one of don't keep people from committing ethical violations, simply find ways of getting them off the hook when they do. And that, unfortunately, has resulted in a lot of people getting away with a lot of things, the public seeing it, and after a while we look at things like Fajita Gate and whatever, other thing come along and start to get the impression that the only way the city is going to take any action against its own is if the feds come in, the FBI comes in, the Attorney General comes in, and that's what we're seeing now with the bundlers in the mayor's office that are being taken to jail. That's what we saw with the state senator, Leland Yee. The only reason he was held accountable was because people from the outside came in. And that really does diminish not only the expectations of the public, but also the credibility of anybody that is dealing with ethics issues, because the question, is always, well, we know what they did. It looks on the face of it just horrendous, and they never come out and say, let's disclose. Believe me, I've been going to these public meetings here in San Francisco for 9 years, and I've never seen anybody disclose.
Thank you.
Larry Bush, on behalf of Friends of Ethics, I would just point out that by going into closed session, you are allowing Mark Farrell to again avoid appearing in front of the commission. And he has not only said he will not come before the commission, he's actually bragged in a newspaper article in February saying there's no reason for Farrell to waste his time coming to the commission. So he is in your face saying he doesn't need to be doing anything with you all. Unless your closed session is exclusively on the law and not on any of the other atmosphere that's going on with this, such as the likelihood that the budget chair of the Board of Supervisors is going to sue the city to recover money for Jim Sutton, of all people. I think it's impossible to imagine that he is going to take the risk of bad publicity of suing the city to recover Sutton's fees. So to the extent that your conversation in closed meeting is entirely about the legal merits and not about the merits of settling the case, I would support closed session, but otherwise all in public. Thank you.
May I ask a question? I'm just curious, is Mr. Farrell's attorney here? Huh?
Yes.
He is, okay. All right.
Mr. Chair, without going into any of the legal...
Before you, is there any other public comment?
Dr. Derek Kerr again. In this case, the Ethics Commission took a stand against the impunity of big money in political campaigns. You could have backed down for a number of reasons. Your former executive director remained inert and kept you in the dark during a 4-year FPPC investigation. The city attorney's office dodged this case, trembling about the statute of limitations. Under pressure from the Sutton law firm and the city attorney, Mr. St. Croix caved. Then you were seeking a budget increase before the Budget and Finance Committee that is chaired by Supervisor Farrell. And Supervisor Farrell refused to appear before you, calling it a waste of time. So in view of these factors, I think that the Ethics Commission performed courageously and honorably. Small as it is, the $25,000 settlement proposal represents an advance for this commission and for campaign ethics. Thank you very much.
Thank you. Any other public comment?
Yes, Starchild again with the Libertarian Party of San Francisco. I agree with the previous gentleman who spoke in favor of discussing this openly. Unless there are specific things that you're legally prohibited from discussing openly, I think openness is always the best policy. And I know nothing about the particular case in question, so I don't have a horse in the fight. For all I know, maybe Mark Farrell has a legitimate case. Maybe he doesn't. I don't know. But I think whatever the truth is better served by discussing it out in public as much as possible. If you feel you can't do that, I would recommend a couple steps. First, identifying very narrowly and specifically the things that do need to be discussed secretly, and discussing everything else out in the open. Second, putting a sunset clause on the secrecy so that it's not in perpetuity, but that it automatically becomes public after a certain date, say after the lawsuit is out of the courts and settled, or after a certain length of time, et cetera. You can craft language on that if you wanted. My other suggestion is to, if you're going into the closed session for an uncertain amount of time, if you can't tell the public in advance how long you're going to be in the private meeting, then have public comment first, so those of us who wish to comment afterwards don't have to wait around for an indefinite period of time while you're doing the secret meeting. But I would urge you to consider the possibility of not having a secret meeting, especially if that would result in an appearance before your commission and open public discussion of things that won't happen otherwise, as the previous speaker seemed to be suggesting would be the case. Thank you.
Thank you. Any other comment?
Charles Marsteller again. I wanted to say that I'm not an attorney, and I'm glad most of you are on a matter like this. I do, however, question whether this issue is ripe, and I guess I mean that more literally liberally than in the legal sense. I realize it's right because it's before you, but on the other hand, I would say, how many of you have read the FPPC investigative report and understand the implications as it applies to this settlement or to this case here in San Francisco, because I see, and others have seen, aspects of that report that indicate possible issues that should be raised with the district attorney or become a matter of criminal law. As I say, though, I'm not an attorney, but it seems to me that it bears on this case, and I think if you have the latitude, that question should be raised in your deliberations. I don't know if you're making strictly decisions based on the factual record, or you can go back and look at the FPPC report, but if you have to do that, my guess is you'll want to read it thoroughly and understand the implied portions of it that indicate possible criminal intent or criminal violation, and as a result, that might delay your decision today.
Any other public comment? I'm hearing none. I'll call the question. All those, oh, I'm sorry.
Charles Bell, McKenders, and Hilltack. I'd just like to ask a question. If you go into closed session, you intend to come out and deliberate the matter in public? Because I would like to at least have an opportunity to comment on that.
Well,
I know you have a right to go into closed session to discuss legal matters that the city attorney may want to
That
present.
would be a subject matter, when we're in closed session, deciding what disclosures we wish to make as to the decision and the reasons for the decision.
Well, if it's uncertain as to whether you're going to make a decision in closed session, then let me just briefly comment. I've appeared before you before on this matter. In our view, the Farrell Concerned Citizens matter was one of the greatest frauds on San Francisco voters in recent history. Farrell was able to essentially double the amount of contribution limited money that he used for campaign purposes in a very close election, the outcome of which may well have been affected by that substantial amount of money. You commendably, in my view, took the bit and made a decision to go forward with the forfeiture action in July. And there was quite a bit of presentation before you about a number of issues, including the statute of limitations issue and the fraudulent concealment exception to that. I'm not going to belabor that because I briefed it extensively and discussed it extensively and answered questions of commissioners during public comment. But you now have a settlement before you. I understand the concerns about potential liability in such circumstances, but I think that the important thing to bear in mind, the commendable action that you did take in July, is that there is a public issue here as well. What kind of signal is sent by the settlement? What is the respondent, in this case, the supervisor, going to be held responsible in a way that he acknowledges? One of the things that was troublesome about the FPPC matter, which I discussed with you, I gave him 2 cheers for entering into it, but Mr. Farrell's agent was permitted to essentially admit liability before the FPPC. Mr. Farrell was not required by the FPPC to make any sign on the dotted line on that settlement admitting any liability himself. As a result of that and comments made to the FPPC, they have ceased allowing that to occur. So a candidate in the case of a situation where control committee violation is found, is required to sign the stipulation. So let me just conclude with that. I think that the important thing, regardless of where you go on this in terms of the fine, which is not substantial in relation to the total amount of the forfeiture, is the personal liability, the assumption of personal responsibility for it. Thank you.
Thank you.
Mr. Chairman, before we've already voted.
No, we haven't voted.
All right. Well, it doesn't matter.
I'll call
before.
the question.
Well, I want to, something comes to me. One of the speakers raises the question, even an implication, that this commission is somehow influenced by Mr. Farrell's vote in what, committee and then on the full Board of Supervisors floor to approve the requested budget. Let the record show that I wrote the city, I think it was the city attorney, or whether maybe it was Mr. Farrell directly, a letter demanding that he recuse himself from voting in the committee. What committee is it? The Budget Committee? Yeah, I think it was to him demanding he recuse, because there was speculation that he would punish the commission for having the gall to engage in litigation with a cross-complaint against him. In any event, the rest of the record is clear that he voted for the budget there in the Budget Committee, voted for it at the Board of Supervisors. But I can't imagine any member of the commission or its executive director or other members of the staff being influenced by that series of events.
All right, I'll call the question on going into closed session. All in favor?
Aye.
Opposed? Carried unanimously. We'll go into closed session. I can only guess when we will come back into open session. I would expect a half hour at a minimum and probably longer.
Okay.
We'll close the doors and the public will leave.
We don't go in the back?
No, we stay here.
Oh, all right.
SF Gov TV, San Francisco Government Television.
Executive Director of the San Francisco Department on the Status of Women. Welcome to our event to mark Domestic Violence Awareness Month. So I want to really invite the folks with the signs to come on in, walk in closer. Before I introduce our speakers tonight, I want to recognize the domestic violence survivors among us. They deserve our continued support and a round of applause for our survivors. Next, I want to recognize the frontline staff of our partner agencies and all of the folks here who work on fighting domestic violence every day. Let's show them our appreciation. Domestic violence continues to be a huge problem in San Francisco. Last year, there were almost 9,000 911 calls for help, 3,000 domestic violence cases reported to the police department, and according to official counts, we lost 4 lives in the last 2 years. We're so fortunate to have a mayor who has made ending violence against women, including domestic violence, a priority. At the beginning of Mayor Lee's tenure in 2011, the city was investing just under $3 million a year in direct services to survivors of domestic violence, sexual assault, and human trafficking. I'm very proud to say that under Mayor Lee's leadership, this funding has increased by an incredible 116% to $6.3 million today. Without further ado, please help me welcome our mayor, Edwin Lee, a true leader in ending violence against women. Please give him a warm welcome.
Thank you. Thank you, Emily, and everyone. Welcome to City Hall. As you all know, October marks Domestic Violence Awareness Month, and I want to say thank you to members of our Board of Supervisors. I know Supervisor Campos and Supervisor Wiener are here today, because I don't just hand out money. I got to do it in partnership with the board. And just so happens they agree with me that funding for more doors to safety is really important for the city. And, you know, let me say something here. I think, you know, domestic violence and abuse of loved ones most of the time happen behind doors. And so we're trying to open more doors so it doesn't happen. And that's why we have resources to spend to make sure that our prosecutors, number one, and our DA and our police department are working together to make sure we hold individuals accountable. And that's, of course, our criminal justice system. But we also know, given the great work that our department, our Status of Women, our great, wonderful community-based nonprofits that are working every day have seen other doors close, and we have opened them up because we need a school system that educates our youth. Violence is not acceptable. It may be good for certain types of sports to hit a ball, but it's never good to hit another person. That's what education door is opened with this funding. We need our health care centers to have their doors open so we can treat and find those that are abused and help them out of that misery. We have our housing authority. We're opening their doors to make sure public housing residents don't feel any less than anybody to get treatment and support. We open up the workplace to make sure that we can talk about it and that reports can be made around domestic violence. Our schools, our youth are there to help us prevent and to support those who are victims. All of these systems, we are opening more doors with this resource. And so I've been very proud to work with the board to increase funding. It's not so much about the dollar amount. We actually all have to feel that we've completed every single door opening to make sure we prevent violence, because every time we hear of that fatality, we look upon ourselves and say, what did we not do to try to prevent that from happening? And that's why we're going to be even more successful. Finally, we're in the process of creating a brand new program, again, to connect survivors of domestic violence who call the police. We want to connect them immediately to an advocate to make sure all the things are done properly at the very time that person, that victim, is in need. And we're going to do that with this additional funding. We're using data from the Family Violence Council report to start this program, and we're starting it right in the Bayview because the Bayview and the Bayview District has the highest call volume of 911 calls related to domestic violence. So let us all keep focused. Let us make sure that not only are we making awareness, but we're actually investing in the very programs that will end domestic violence. And with that, I'm happy again tonight to announce for the fourth time, with everybody's support, but especially with the support, maybe it's 6 million times support from our San Francisco Giants. Tonight, City Hall will be lit in purple for the support that we have for awareness of domestic violence. Let us all celebrate that and continue with the Giants. Thank you.
Thank you so much, Mr. Mayor. Next, please help me welcome someone who represents the heart of the community, my dear friend, woman warrior, the fierce Beverly Upton, Executive Director of the Domestic Violence Consortium, who has a very special presentation to make to the mayor. Beverly.
Well, if you know me, you've heard me say before, I have the best job in the world. Now I have the best job in the best city in the world. So thank you so much. We are really here today with this letter signed by so many of you that are ending violence against women, violence against children, violence against transgender women, violence against the LGBTQ community. We are here to say we stand together to end domestic violence. We want to take a moment to thank Mayor Ed Lee for his continuing support, for raising those dollars for us, for the Board of Supervisors, for really making this a priority and really raising the issue that this hurts everybody who lives in San Francisco. So we just want to take a moment to thank you for your continued support, Mayor Lee, your continued support, and also may the purple on City Hall be a beacon to everyone in San Francisco and beyond for safety, justice, and healing. Thank you so much.
Thank you so much, Beverly. That's such an important acknowledgement of the city's support. Next, I want to welcome Supervisor Scott Wiener, who stands with us today in this fight to end violence against women. Please welcome Supervisor Scott Wiener.
Good evening and welcome everyone to San Francisco City Hall. I especially want to welcome our students from School of the Arts in the district I represent. Welcome to City Hall. Thank you. So domestic violence, it's one of those things that it is always present and it's often just underneath the surface. And I think a lot of times people don't talk about it. And it's very silent, and it's secret, and it's hidden, but it is always, always there, and it is deep and broad and toxic in its impact on our community. And once in a while, something happens that brings it to the surface, and people finally start talking. That happened 4 years ago this month. In this building when, sadly, the Board of Supervisors, a minority of the Board of Supervisors, made the wrong decision in allowing our sheriff to keep serving. I'll just call it out. And that was one of those moments when people started to talk. And I remember in the days and weeks after that unfortunate decision, a tragic decision, I really was reminded how broad and deep this problem is. The people that would talk to me about their experience in a relationship, about their experience as a child observing or seeing one parent abusing another parent, or the experience that they had with a college roommate or a friend who had been abused. People who haven't been abused, but it has impacted their lives. And how many people in this city, in this society, have been deeply, deeply affected? Yeah. Have been deeply affected by domestic violence. And so it is so important to talk about it and not just to sweep it under the rug or quietly take care of it. We need to be talking about this problem because that is the only way that we're going to put an end to it once and for all. So let's keep fighting. Thank you.
Thank you so much, Scott. I want to acknowledge a few senior officials who have joined us. Assessor Recorder Carmen Chu is here with us today. And then if you might hold your applause, we also have Liz Aguilar-Tarky and Jackie Ortiz of the District Attorney's Office, if you want to wave. Police Captain Una Bailey of the Special Victims Unit. Police Commander Greg McEachran, and Adult Probation Chief Karen Fletcher. If we could give them all a big round of applause. I also want to thank Mayor's Deputy Chief of Staff Paul Henderson and our budget analyst Laura Bush, who has joined us today. And Chief Fletcher asked me to make one quick announcement to save the date for Friday, October 28th, 9 a.m. to 2 p.m. Adult Probation Department is having a Domestic Violence Awareness Month event supporting veterans and survivors of family violence from trauma to healing at the War Memorial Veterans Building from 9 a.m. to 2 p.m. So please plan to join us there. Next, I'd like to introduce another important male ally, Dr. Curtis Chan, Medical Director of the Maternal, Child, and Adolescent Health Section and Deputy Health Director at the San Francisco Department of Public Health. Please help me welcome Dr. Chan.
Thank you, Emily. I just want to spend my 5 minutes just giving a little bit of the data that reflects Supervisor Wiener's and the mayor's sentiments about us coming together, the mayor's sentiments, and also the prevalence, underlying prevalence that we all know is in San Francisco. So most of us know that the prevalence is that 1 in 3 women have been victims of intimate partner violence in the United States. Something in San Francisco, though, we now know amongst our most vulnerable women, those who are in pregnancy, those 9 months in pregnancy, there's a wide disparity in ethnicity as well as socioeconomic class. So amongst those who are most stressed, those in poverty, the prevalence is 11%. That's about 3 times higher than those who are not in poverty. So that really speaks to the increasing gap between the haves and have-nots in San Francisco and what that does to all of us. So I'm in public health and I'm a pediatrician, and I could tell you that this issue profoundly affects both women and children. So this prevalence of domestic violence experienced by low-income women and women of all classes causes an increase in coping and reactive behaviors, and that's why we have this link in intimate partner violence, causing a 4-fold increased risk in drug use, a 5-fold risk in depression, and of course, increased risk of suicidality. And this affects their babies too. Women who are experiencing intimate partner violence have 3 times more likely to have a baby who was born preterm or low birth weight. So this all attributes to a life course of consequences in child abuse, neglect, and drug addiction. So, but there's hope. In the health community and research, we now recognize and understand that your interventions are effective. Primary care interventions are effective, counseling and community-based interventions are effective. So that's why it's more and more important that we come together, integrate our community programs and health services so that we could better address this issue as an entire community. One great example is at our county hospital, led by many of you advocates and an internal medicine physician that we all know and love, Dr. Lee Kimberg. She's received a federal grant, the ARISE grant, that really builds upon the partnership of San Francisco General Hospital, UCSF, Bay Area Legal Aid, La Casa de la Madres, Futures Without Violence, and the Trauma Recovery Center to provide integrated screening, counseling, quality counseling, and effective referrals to all the women who go through our county health system. So this type of integration we feel is very promising. It's a national leader, and it's becoming a national model of how we in San Francisco can integrate our services better to serve our most vulnerable population at their most vulnerable times. Thank you very much for all your service.
Thank you very much, Dr. Chan. I also want to acknowledge Kathy Gorwood, who's here representing Sheriff Vicki Hennessy. And our Assessor Recorder, Carmen Chu, would like to say a few words.
Thank you. My name is Carmen Chu. I serve as San Francisco's elected assessor, and I am so honored to stand here with Beverly, with you, Emily, and all of our community partners to bring awareness to domestic violence. My comments will be short. When I stand here today, I just see how wonderful it is to see the over 100 people who are here, all behind us, but also in front of us, who came out because they understand just how important this cause is to bring awareness. And I know that here we have 100 people already who know that they can each play a role when they see domestic violence happening, or they're worried that domestic violence might be happening, that they're going to do something, that we all take a pledge to do something about it and to make sure that our loved ones aren't suffering alone. Emily was just telling me that there are a ton of resources that are available and listed on the Department of Status of Women's website. I encourage everybody who's here today who care about this issue, please take a look at it. If you know anybody, any of your friends, any of your family who might be going through something where they may not be yet ready to talk about it, please don't let them suffer in silence. Please reach out to them. Please be a shoulder. Please share with them all the ways that we might be able to help them. I think that's the only way that we're really going to end domestic violence. And so with that, congratulations, Emily, on your tireless leadership year in and year out. Thank you.
Thank you so much, Carmen. Next, I want to introduce two courageous young women who will share their stories. Carmen Chen and Gabby Molina are high school seniors who participate in the Young Asian Women Against Violence project of the Community Youth Center. Let's give it up for Carmen and Gabby.
Hi, my name is Gabby. Hi, my name is Carmen. We are from a leadership program called Young Asian Women Against Violence, YAWAVE for short, part of the Community Youth Center.
YAWAVE is a program dedicated to positive empowerment and development of API high school youth young Asian women in San Francisco. YAWAVE creates a safe space to strengthen the resilience, pride, healing, and knowledge of young Asian women, to advocate for the end of gender-based violence in our community. We educate about violence against women through creating and facilitating workshops. Education creates long-term effect rather than a band-aid solution, enabling us to create a foundation of change.
Together, we stand in solidarity with 15-year-old Brescia Meadows, who was incarcerated for defending herself and her family from her abusive father. Today is the day of Brescia's court hearing. Instead of being given a safe space to heal, she is being isolated from her community, from her loved ones, as she faces prosecution. Brescia is not much younger than us. It angers us to see one of our own peers being punished for defending herself.
Why are systems that are supposed to protect us harming us? As youth, our experiences are often invalidated. We have few opportunities to speak up for ourselves. We are disempowered. There are limited resources and space for healing and safety. And it's really rare for us to find these opportunities and resources. How can someone with no institutional power fight for the things that they need against a system that fights against them?
In a society where youth hold less power than adults, we need spaces for us to be heard, for survivors to be visible and validated. YAWAVE provides a space for young women to share their ideas and experiences and creates an opportunity to heal and grow from trauma. Youth are capable, but we need a community who is willing to stand with us in times of need, rather than turning away. The end of violence starts with us.
We urge you to keep your ears open to the voices of youth.
To keep your mind open, to learn.
to keep your heart open to our experiences.
We urge you to stand in solidarity with those of us who are oppressed.
Stand with Brescia.
Stand with incarcerated youth.
Stand with survivors of violence.
Thank you, Carmen and Gabby. We have a whole crew here from Community Youth Center. If you want to wave, CYC, let's give it up for CYC. Next, I'm pleased to invite Delia Gennario of the Sheriff's Department, who can provide us with an update on the positive changes resulting from the leadership of Sheriff Vicki Hennessy. Please welcome Delia.
Good afternoon, everyone. Again, I'm Delia Gennario. I'm the Survivor Restoration Director for the San Francisco Sheriff's Department. And as I look out at all of you, I'm reminded once again how important it is for our community to come together to support survivors of domestic violence. I have had the honor in working in our Sheriff's Department for over 20 years and proud to be in the position that I am as the director of our program for the survivors. I would just like to take a moment to share how the Sheriff's Department has supported innovative programs for domestic violence survivors over the years and continues under our new Sheriff, Vicki Hennessy, to not only provide those same services, but also we have enhanced them. Many of you in the audience, I know about our Resolve to Stop the Violence program, our RSVP program that was started in 1997. Yes, it's been 20 years, and it's still here, going strong. But it was the first restorative justice jail program in the United States that housed together specifically worked with male offenders who have violence documented in their criminal history, particularly domestic violence. And again, that program is still going strong today. In fact, with our court collaborations in 2015, RSVP participants that were in custody for domestic violence increased 93%, which was a substantial increase from 2014, which was only 20%. The Sheriff's Department also has our out-of-custody community programs utilizing the violence prevention program, Man Alive, which is used in both our community programs and in custody programs. While we do need programs to hold offenders accountable and to give opportunities for them to change their behavior, we need to equally and more so provide services for our survivors of domestic violence. The San Francisco Survivor Restoration Program, which I have been honored to be over for about 20 years, provides services for survivors through their own process of restoration, empowerment, and providing opportunities for them to contribute to the development, implementation, and evaluation of all the key components of the program. And as we know, as we all know, the importance of having survivor voices at all our tables. We offer with our sister community agencies, that many of them are here today, direct crisis services through our survivor assessment response program, along with our empowerment groups, which is under our survivor empowerment program, which I would also like to give a very special acknowledgement to my staff that's out here and my team, that together with their fierce advocacy in 2015, as we supported 65 survivors who obtained their U visas, 6 survivors were granted political asylum, 12 received permanent residency, and the total of 51 DV survivors graduated from our empowerment program. Our newest program in the Sheriff's Department is our Survivor in Custody program, a reentry program. We make contact with incarcerated survivors of domestic violence and provides resources which are trauma-informed and culturally responsive to the many challenges that they face. These services are also provided for our incarcerated DV trans women, stalking, and trafficking victims. I will just end with this quote, one of my favorites. It's really simple, from Helen Keller, that I love, and it's simple as to say, alone we can do so little, but together we can do so much. And when I look around with all the agencies here and the hard work in changing our systems together, we can definitely make a change. Thank you.
Thank you so much, Delia. I just want to acknowledge a couple of staff people who are here. Ami Alden from Assemblymember Phil Ting's office and Carolina Morales with Supervisor David Campos' office. The supervisor was here earlier. I also want to acknowledge our Family Violence Council Tri-Chair Katie Albright, who is here as well. Next up is Cara Duggan, Community Education and Volunteer Manager at La Casa de las Madres, which opened in 1976 as the first domestic violence shelter in the state of California and only the second in the nation. Please welcome Cara.
I'm going to put this down, but I was holding the door to shelter. Good evening. It's wonderful to be here with all of you standing in support of domestic violence survivors. Over 40 years ago, La Casa de las Madres began as a small shelter for battered women in San Francisco. Today, La Casa is still providing emergency services to women and children in need through our confidential shelter and 24-hour crisis line. We also provide counseling, case management, support groups, a teen program, and legal services at our drop-in center over on Mission Street. 4 of our advocates work at the only 2 women-specific supportive housing sites in San Francisco, providing emotional and practical support to over 150 female residents. This partnership is entering its 18th year. La Casa has also had the opportunity to extend our support services in San Francisco by providing targeted programming to specific populations alongside amazing community partners. I'd like to highlight 4 of these programs today. First, we are proud to be a part of the ARISE program at Zuckerberg San Francisco General Hospital. A La Casa advocate is on site to meet with patients that disclose instances of intimate partner violence to their physicians. Our advocate will provide danger and risk assessment, safety planning, brief counseling, and resources and referrals. This individual will also provide training on intimate partner violence to healthcare professionals. Second, funded by the Department on the Status of Women, La Casa advocates are also co-located at the San Francisco Housing Authority. As many of us know, survivors face unique challenges navigating the public housing system here in San Francisco. We work to ensure these individuals have safe places to live and to raise their families. Our advocates at the Housing Authority also educate property management and support staff at housing sites across the Bay Area about domestic violence. This work helps strengthen the response of subsidized housing communities to incidents of domestic violence on site. Third, there's a La Casa advocate at 850 Bryant Street, the Hall of Justice. This individual follows up on police reports of domestic violence to provide the survivor with resources, referrals, and support. And finally, and as mentioned earlier, in partnership with the department, GLIDE, SFPD, and Bayview FRC, we'll have a La Casa advocate co-located at the Bayview responding to all high lethality domestic violence situations. These 4 programs allow our staff, co-located at the hospital, SROs, the Housing Authority, Hall of Justice, and the Bayview, to provide advocacy, support, resources, and referrals to survivors. Survivors that are navigating complex processes, made even more challenging by experiences of trauma. We're proud at La Casa to be part of the first line of response to survivors of domestic violence. And we're proud to serve as a continued support system to survivors on their path to healing. And of course, we're proud to be part of a community of organizations, many of whom are here today, that is working tirelessly to end domestic violence in San Francisco. Thank you.
Thanks so much, Cara. I want to acknowledge the Executive Director of La Casa de las Madres, Kathy Black, who is here in the audience. We have another co-chair of the Family Violence Council, Shauna Reeves, is also here. Our last speaker is Commissioner on the Status of Women, Olga Ryerson. She's our newest commissioner who joined after retiring from an exceptional 40-year career in city service, much of which was working as Mayor Lee's invaluable assistant. Please welcome Commissioner on the Status of Women, Olga Ryerson.
Thank you. Good evening, everyone. Thank you so much for coming to this important event. We gather annually in October to recognize Domestic Violence Awareness Month. to celebrate how far we've come and to renew our efforts on what we still need to do to end intimate partner violence. In San Francisco, in fiscal year 2015, the Department of Emergency Management received 8,719 calls related to domestic violence. 1 in 13 violent crime calls are family violence related. In 2015, domestic violence was the second most common violent crime to which the police department responded. During that same time, our community partners received over 21,000 calls to their domestic violence hotline, nearly 3 times as many as 911. This shows the importance of having multifaceted response to domestic violence. Many survivors may not want to involve the criminal justice system, and so we must ensure that we open many doors to safety so that different systems can assist survivors of domestic violence to be safe. Today, we have heard from our healthcare system and the wonderful work that the Department of Public Health and San Francisco General Hospital are doing. We have heard from our community-based service providers who provide counseling, shelter, legal services, and advocacy. We have heard from our peer educators who provide cultural prevention services by working with youth to help teach healthy relationship skills. We have heard from our law enforcement colleagues at the Sheriff's Department who do not just house domestic violence offenders, but provide innovative programs to both victims and perpetrators of abuse in our jails. And of course, we have heard from our city leaders who help ensure that we fund our public agencies and the vital community-based services for domestic violence survivors. The Commission on the Status of Women is celebrating its 40th anniversary this year. From our earliest years, we have focused on responding to domestic violence. The first program we funded was La Casa de las Madres with a $75,000 grant. La Casa, as you heard earlier, was the first domestic violence shelter in California and the second in the United States. How amazing is it that we've gone from one $75,000 grant to one program to our now over $6 million in funds to 27 different agencies. But our work is going on. In the past 2 years, there have been 4 domestic violence-related homicides each year. 2 out of those 4 domestic violence homicides in 2015 involved guns. We cannot stop our work until no one is killed by an intimate partner. Thank you for joining us. Together, we will one day end domestic violence.
Thank you so much, Olga. I want to acknowledge Jeff Kositsky, head of the Department of Homelessness and Supportive Housing, who has joined us. To close our event today, I want to introduce the Anacrusis Treble Ensemble from the Ruth Asawa School of the Arts. Under the direction of Kristen Greca, the ensemble will sing a piece that sets to music a text by the famous African-American poet Audre Lorde. She who makes her meaning clear, Gamba Adisa. Please give it up for the Anacrusis Treble Ensemble.
We'll reconvene in open session, and the first item for discussion is whether or not the commission should disclose the closed session deliberation. Do I hear a motion in that regard?
I move that we disclose the closed session deliberation.
Second.
Right. Any discussion? All right. Call the vote. All in favor of disclosing the discussion?
Aye.
Aye. Opposed? It's carried unanimously. All right, I guess as chair I will start off with saying that the commission voted 3-2 in favor of accepting the settlement. And I would like to just spend a few minutes explaining why I supported the settlement, and so that the public can understand the reasoning and how I came to the position of supporting it. As you may recall, when this matter was first sent to the Treasurer's Office for collection, the Commission authorized me to see whether or not there was a way in which it could be resolved short of litigation. A mediation was set up with Judge Warren as a mediator, and I was there as the representative of the Commission with the understanding that I didn't have any authority to enter into a settlement. I was there only to state the Commission's position, and said that it was essentially we had to have two things. We had to have a admission of responsibility by Mr. Farrell for the wrongdoing of the committee, and we needed a significant payment of a fine. Didn't specify what the dollar amount would be, but those were the two elements. And in the course of the mediation, and because mediations are confidential, I can't go into it, Mr. Farrell came with a proposed settlement, although the terms of the settlement agreement and what terms were going to be agreed to had not been finalized. Came with an offer to settle, which I took back to the Commission, and it was rejected as inadequate in amount. And when I conveyed that information to Mr. Farrell, that he had to come up with some much more substantial amount than he was talking about, that if he was going to get us to enter into a settlement. The next day they filed suit. And attacking the legal position and the procedural position that the Commission had taken in trying to enforce the forfeiture. We then filed an answer, then filed a cross-complaint in which we rejected his claims and we were seeking the total amount of the forfeiture sum. And he filed an answer to that. And in his filings, and he filed all of them under oath. In other words, it was not the attorneys filing it, but he swore under oath to the truth of the documents. And in that complaint that he filed, he swore under oath that he knew nothing about the creation of the committee, that he had no knowledge of his agents' activities, and then they subsequently filed the anti-SLAPP motion with the court, which was scheduled to be heard, I guess, about a month and a half ago, because there's a statutory period of how much time you have unless the parties agree to extend it. Meanwhile, the city attorney's office was working hard to see whether or not she could get some kind of a settlement, particularly in the face of the SLAPP motion, which, if we were to not prevail, the city would be obligated for what we assume were very substantial legal fees. And the city attorney's office, Sarah, did yeoman's job trying to get the sums up, trying to get the language in the agreement as to his accepting responsibility, and eventually was able to get him to the $25,000, which was in the settlement that I approved, that I agreed to, which I thought was a very significant amount of money, and I think sends a very strong message. And when this matter was first sent to the treasurer and with instructions to proceed to collect, I always had troubles procedurally as to what had happened procedurally and also substantively as to whether or not we were going to prevail. But I think we all felt, what's the choice? We're going to try and enforce it and see what happens. But with the exception of Commissioner Kopp, I'm probably the oldest lawyer in this room and the longest period of being a trial lawyer. Spent my whole life trying cases in this courthouse and in courthouses around the country, and understand the vagaries of litigation. And it was my judgment, based upon Sarah's analysis of the case, that the settlement was in our best interests and the best interests of the citizens of San Francisco. I know that some of the other commissioners don't feel that we got as clear a statement of responsibility in the settlement agreement, but I'm convinced we got as strong a statement as we could get, where he said he acknowledges that he has the ultimate responsibility for the wrongful acts of Mark Farrell for District 2 Supervisor 2010 Committee and its agents. So that it's not a question you say, I didn't do anything. He's admitting he has the responsibility to keep his agents abiding by the law. So that on balance, I think it's a good disposition. Any other commissioners want to weigh in?
Mr. Chair,
Mr. Keene?
I would have voted for the $25,000 settlement, mainly because I was convinced by our attorney, Sarah, who did an amazing job and came at it, and she and I argued for hours and hours over a number of weekends in regard to her conclusions versus mine, that ultimately the case would be lost on the statute of limitations, not on the merits, that we'd never get to the merits of whether or not Mark Farrell did indeed intentionally, deliberately, and fraudulently set up, be involved in the coordination of this committee with his own committee, which is one of the most egregious things that a modern politician can do in regard to campaign contributions, in terms of fraudulently laundering campaign contributions. I still believe he did that. But I don't believe we would have gotten there because of the statute of limitations. I believe that if we had, the merits would have been decided clearly on a couple of things, mainly the fact that $200,000, which was almost the entire amount that that committee spent, was gotten from two individuals, two socially prominent individuals, Pacific Heights individuals, Dee Dee Wilsey, Tom Coates, both friends of Mark Farrell's, both whom had been with Mark Farrell at an event the night before they wrote the checks. And the FPPC never even interviewed these people. When they gave their judgment, they just found that once Chris Lee, this little lackey of Farrell's, fell on his sword and said, "Oh, I did it all," that was enough, and under the law that is enough, because he's ultimately responsible for the actions of his agents if they're using another committee to commingle. But so that was the end of the FPPC. The FPPC never made a finding that Farrell was not involved in this commingling activity. That is simply an untruth. And they just stuck with the whole idea, okay, we've got the case made because of Chris Lee. So, again, I was ready to vote for the settlement, for the $25,000 settlement, reluctantly, except for the language that Farrell's lawyer and Farrell just tenaciously insisted be in the recital A of the settlement, which talks about, as our chair says, it does admit that Farrell acknowledges that he has the ultimate responsibility for the wrongful acts, but that it also says he was not aware of Mr. Lee's actions, and that the Ethics Commission concurs with the FPC's conclusions. The FPC didn't conclude that. We should not concur with that, because that is simply false. And if we could get to a trial on the merits, any lawyer worth their salt could have proven that that was false, and that Farrell was up to his neck in regard to this fraudulent, illegal campaign contribution that he was getting from this committee that had been set up, that had been financed by his rich friends. The last thing I want to talk about is in regard to the fact as to how we got to this point to begin with. And that is the Ethics Commission, as a commission, bears tremendous responsibility for this. And the responsibility, all of it falls on the former executive director of the Ethics Commission, John St. Croix, who was clearly totally incompetent in allowing the statute of limitations to run, or either marginally corrupt by going along with the whole idea of not pursuing it until it did run. And that, as a result of that, which is, by the way, the reason St. Croix is no longer with us. That's the underlying reason. He's not here. And decided to retire, because otherwise he knew he was gonna get the fire that is coming now in regard to this. He didn't get it. He got it at the time in a closed session when it was brought to us by the city attorney that it looked like the statute of limitations had run. And City Attorney Dennis Herrera, by the way, I'm not doing about anything out of school in terms of a closed session, he was furious. So the city attorney's office bears no responsibility for this. He was furious at Farrell, too. At St. Croix, too. So we are here because we had, for many years, a director who did not serve the people of San Francisco, who did not do his job, and allowed probably the most egregious act of a politician in terms of money laundering and campaign contributions to take place in San Francisco's history, and pretty much got away with it. Didn't get away with it. We got a statement of responsibility, but the weasel language in that statement of responsibility is going to be spun tomorrow by Mr. Sutton and by Mr. Farrell as, see, the Ethics Commission agrees I had nothing to do with it. That's not true. Also, the last thing that should be commented about is that Mr. Farrell, an elected supervisor of the city and county of San Francisco, has never had the political will or courage or integrity to come before this commission, this Ethics Commission, and look us in the face and address it and say the things that his lawyer has negotiated for him. And the lawyer negotiated for him very well. Nothing against Mr. Sutton. He did a hell of a job, and I hope he's getting a hell of a fee. At least that will help as well in terms of but Mark Farrell has a lot to be ashamed of. And the voters in the city and county of San Francisco should know that, and they should not accept any kind of spin that he's going to put on it now, that it's over. Even the Ethics Commission, they agreed, I didn't have anything to do with this. He did.
I'd be recognized. I adopt all the statements Commissioner Keene has just made. He has been a member of this commission much longer than I, and during the period in which this litigation was generated. I want it clear that it is not my conclusion that Mark Farrell did not authorize the actions of his former campaign consultant with respect to common sense voters. I note that Mr. Farrell's attorney has departed, which indicates some of the same disdain for the Ethics Commission, which his client demonstrated with remarks to the effect of not appearing at the Ethics Commission because it was a waste of time. There are certainly knotty, to use a trite word, legal issues in the pending litigation. And as a footnote, I'm exercised by the fact that I was in the California State Senate and was a supporter of the then President Pro Tem Bill Lockyer, who was the author of the strategic lawsuit against public policy statute, which has been invoked in the pending motion to dismiss the Ethics Commission's cross-complaint. And I can state that that legislation was never meant to apply to a city and county attempting to enforce laws against cheating in election campaigns. As Commissioner Keene noted in different words, This is a case based upon a prior city employee's malpractice. If he was in private employment, he'd be the subject of a lawsuit for damages himself. Like Commissioner Keene, I would probably accept the $25,000 compromise payment. I will not, however, accept the recitals unnecessary in a settlement agreement. Recitals that were, of course, a result of a practice of the city attorney's office, of which I've had no prior knowledge of including recitals in a settlement agreement. A settlement agreement can be on one page. There's a dispute between you and me, and I'm paying you $25,000 if you'll dismiss your suit against me and release me from any claims, and I'll release you from any claims against me. These recitals are intended with the unfortunate custom and practice of the city attorney's office for Mr. Farrell to escape public opprobrium for his cheating conduct. In any event, I am pleased, Mr. Chairman, that the Commission adopted on motion a policy of permitting each commissioner to express his or her views on the reason for his or her vote. That is important, as citizens have pointed out today. And I suspect that almost everything said in the closed session is being said in public and in this particular session itself. It saddens me. It saddens me to see a cheater get away with recitals that'll be used with a public and with a media that doesn't pay as close attention to the nuances of this litigation as the members of the Commission do. Thank you, Mr. Chairman.
Commissioner Hand?
As a citizen and a voter of San Francisco and the only non-lawyer on this panel, I respect all of the legal opinions of my esteemed colleagues. They are right. But the bottom line is this for the citizens of San Francisco. Supervisor Farrell has taken responsibility for soliciting an illegal contribution, and he's going to pay a fine. It's not as much as we might have liked, but at least it's $25,000 that will be returned to the voters of San Francisco for the illegal contribution that was made to his campaign by individuals during his campaign. So I think that the voters can feel satisfied with that, and we hope that in the future we will take such complaints and deal with them quickly and appropriately so that we don't have something that hangs over the Ethics Commission and over the citizens of San Francisco for an unduly long period of time. So I'm satisfied with the outcome. And just remember, he has taken responsibility and he's paying a major fine.
Commissioner Chu?
I would just like to echo Commissioner Payon's remarks and also Chair Rennie's in that what was important to me was that given the procedural and factual posture of this case and the challenges facing the Commission in proceeding, that we got from Supervisor Farrell a statement of responsibility, although ultimately he did not direct the formation of that commission. He said he does acknowledge and accept responsibility for the acts of his agents. And to me, that was very important for him to put that in writing. And then second, in terms of the amount of the fine, I think that we all would like it to be more than what it is, but it's also real money. It is $25,000. It's more than what he had originally offered to pay, and I think that is a success, and would concur with Commissioner Hayon in that money is rightfully going back to the citizens of San Francisco, and that we will have a different executive director and staff team involved, so that in the event that there are future violations of campaign law, that we will act much more expeditiously and effectively in addressing them.
Thank you. Let me just say, in response to Commissioner Keene's statement saying that the FPPC did not make a finding, the specific language of the decision and order of the FPPC was, the evidence supports the finding that Mark Farrell did not authorize Respondent Lee as an agent of the Farrell Committee to coordinate with the Respondent CSV. And that is the language which was in the recital taken from the FPPC. And in all the sworn documents filed by Supervisor Farrell, he denied any knowledge, and the Commission, one of the things that was important to me, the Commission had no evidence to counter his denial. It's nice to make accusations about his criminal activity, but we had no evidence to support that. Absolutely none. And the only evidence we had was his sworn statement under penalty of perjury that he had nothing to do with it. And we did not make a finding that he didn't. We simply said we concur with the statement that the FPPC made. So there have been, I've got to say, from my point of view, there have been a lot of accusations made against Supervisor Farrell that there is no evidence before the Commission that would support him. But I guess you can tell from the statements that have been made who the three who supported the settlement and the two who dissented from it. And I don't think I'm required, am I, to have public comment on this? We had public comment before. So with that, yes, Commissioner Cobb. Yes.
Do we vote on the record? Public?
No, what Commissioner Rennie already did, it was properly reported when we came out of closed session what the vote was. That it was 3-2, Judge Kopp and Commissioner Keene dissenting.
Okay.
That is sufficient.
All right, turning to item 8. We had public comment on this item. We had this public comment on this item, and I've been advised by the city attorney that we only have one need for one comment on an item, but I'm willing to disregard his instructions, and I'll take public comment.
Respectfully, I think that the comment we had before was on whether to go into closed session and not on the settlement itself.
That's my understanding.
So I would like to point out that what the FPPC said was that there was no evidence to connect him to Mr. Lee. They had no discussion about Mr. Helfand, who was the principal person in the case. Mr. Helfand was also, by the affidavit that was provided to the FPPC, and which I also provided to the Commission, the direct supervisor of Mr. Farrell during this period of time. That certainly does not seem to be an arm's distance kind of relationship. There is nothing in the record that says that Mr. Farrell and Mr. Helfand were not involved together in collusion for this. And I would also like to make sure that the record is very clear that the result of this financing of the independent expenditure was the election of Mr. Farrell to office. He won by a few hundred votes. This was not simply money laundering. This was stealing office. And that's what he ended up doing. And by allowing him to do this in absentia through his attorney, instead of standing up in front of this commission where everybody in the city could see him on the camera, you have allowed this to be under wraps to an extent that I hope in the future you decide as a commission that in such cases the person who's being charged must appear before the commission and take responsibility personally and not just in a signed statement submitted by an attorney.
Thank you.
For the record, I'm Charles Marsteller. I'll be brief. I would say I concur with everything Mr. Bush has said, since we're in that mode. I also want to say that I think while Mr. St. Croix screwed up, clearly the commission itself did not provide as much proactive and concurrent oversight as it needed to. We are all thrilled to see this is changing. And I want to assure the public that I think we're all now on the right track. Finally, after 21 years or so of this existence of this agency, that we're finally starting to smell the coffee. Now, I would say in specifics to this case, like the Lynette Sweet case, there's much to be learned from this mistake. And we need to scrub both of those things, both cases, to see where we could improve process, because after all, as former head of Common Cause in San Francisco, that's my greatest concern, is the integrity of the process, a process which here, as in the Sweet case, had failed. It had failed our public trust on public financing in the Sweet matter, and in this case, on a horrendous stealing of an election. And I think that if we scrub hard enough, we're going to find answers about what things we need to do to make sure this type of crap does not come to us again. We have a lot of ideas already, I think. But I would also say, as Mr. Bush said, I do think that no matter what, even in non-criminal matters, that elected officials should appear before the body to state for the record what they have done in violating the public trust. I realize what I'm saying, but there seems to me they can plead the fifth, and maybe that's what he would have had to have done, but it seems to me that justice was not served in this matter.
Thank you. Any other public comment? All right, turning to item 8, agenda item 8, discussion and possible action on items for future meetings. We had the one earlier today, the thing put on the November agenda. Do any of the commissioners have any?
Yes, I'd like to follow up. It doesn't have to be done with any kind of dispatch. With our going forward to get the charter amended in regard to probable cause hearings so that they're no longer done in closed session, or some other change for probable cause, the way probable cause is determined, but get rid of that secret proceeding that we've had up till now to determine probable cause. Due process doesn't require it, and it goes against the transparency that we want. So at some point in the future, I'd leave it to the executive director to maybe think about it, work on it, put something together, a proposal for it. It can be months down the line, but we ought to do it.
Any public comment on that item?
Public comment is on anything, right?
Any new matters that should be on the agenda?
Yes. The new matter, this is Larry Bush from Friends of Ethics. We were very impressed with the calendar of upcoming agenda items for the next calendar year of 2017. We note that early in the year is a plan to have a community outreach on issues that are relevant to the Ethics Commission. And our experience working on both Prop T this time and Prop C before is that there is a missing piece of stronger outreach to unions in the city as well as to minority organizations. And so I would encourage the Commission to ask the staff to direct a much more robust effort to contact the unions who have a great deal at issue with these matters, as well as the minority communities. We do fairly well with the Latino community, but we do not do very well with the Asian community, and we do not do well with the African American community. So I would just request that that be on your radar.
Thank you.
Good afternoon again, Commissioners, members of the public. I'm Starchild, Outreach Director of the Libertarian Party of San Francisco. I would ask you to place the following item on an agenda for a future meeting. I regret only that it will happen after the election, apparently, since you don't have another meeting scheduled between now and the election. This is actually a matter of electioneering that really should be heard sooner. But I have a photo here for the overhead projector.
Wait, Mr. Chairman, maybe I can shorten that. Is this your memorandum on the blue foot and the red foot?
Yes.
You understand? Yeah. Chairman understands.
Move this up a little bit so I can see the caption down here at the bottom. This is a photo that was published in the San Francisco Examiner in August of footprints at the polling station in the basement of City Hall. As you can see looking at the photo, the footprints are red and blue. All the right footprints are red. All the left footprints are blue. I wrote a letter about this to the head of the elections department, John Arntz, after unsuccessfully trying to get him to return my calls and emails. I finally delivered it in person, was able to speak with him briefly in person. He acknowledged receiving my previous communications, and I asked him why he didn't get back to me. His response was he just didn't think it was important. As I said in the letter, unfortunately, there's little to be done now about any biasing impact this may have had on the election results of the primary election. Our chief concern is to ensure that these footprint stickers or other subtle messaging to influence voters not be placed in future elections, including the upcoming presidential election scheduled for November 8th. He said, unfortunately, in response that they had already purchased the stickers. They were going to put them out again. He was quite dismissive of these concerns, but I think it's well known among the public that the color blue has been widely associated with the Democrats in the media, and Democrats are generally seen as being on the left. And if I could have the image shown up again. And the color red associated commonly with Republicans being seen as on the right. And the caption down here at the bottom, reads, "Red and blue footprints direct voters to polling places at San Francisco City Hall." I mean, the problem is obvious, and I don't think it was coincidental. I think a subtle message was being sent to voters. This is an election between Team A and Team B, the red team and the blue team, the Republicans and the Democrats. Pick your choice here. And, of course, the problem with that is that not everybody is in one of what I call the two old cartel parties. There are many thousands of San Franciscans, especially younger voters, who are abandoning the cartel and who are independents or members of alternative political parties. And I believe these parties, as well as those voters, are being discriminated against by this display. And coming into the building today, I checked in the basement, and the footprints are still out again. However, they did make a change to them. As you can see in the image right now here on the screen, all the left footprints are blue and all the right footprints are red. Now they've redeployed the footprints, but in pairs. So there's like two blue footprints, a left and a right footprint next to each other, and then two red footprints next to each other, and then two blue ones, two red ones. So although they did not tell me they were going to make this change, and they did not acknowledge any wrongdoing, I think they perhaps saw after we brought this to their attention that there was a serious problem. Now, I don't think the problem has been entirely alleviated, although it's lessened. The association with left, right, red, blue under this new configuration that is now presently on the basement floor of City Hall is different, but there still is the issue of they're still using those two colors, red and blue, leading voters to the polling places. I think it is still an issue. The law, as you probably know, bans electioneering near polling places, and I note in the document here about, in response to the Petrellis versus Kawa matter, any person has a right to file a complaint with the Ethics Commission alleging that a city officer or employee has engaged in improper government activity by, and number 4 is abusing his or her city position to advance a private interest. I believe that was done in this case. Someone at the Elections Department, and the buck stops, of course, with the head of the department, conducted this action in a way that advanced a private interest, namely of the two cartel parties. I would ask you to please investigate.
Thank you.
Thank you.
May I respond?
Yes.
I would just like to point out that red and blue are our national colors on the flag. The only thing lacking is white. So I think most people would just see that as a, patriotic colors used at the voting polls. I don't know how many people would actually view it with the, subtlety that you're looking at it. But I respect your point of view, and it sounds as if the Elections Department tried to alleviate or respond to your concern in some way. Maybe not satisfactorily to you, but I just wanted to comment on that.
I think
we said. I think we're done.
I don't know whether that was. I don't think I'd called 9, but you came. Additional opportunity for public comment on matters appearing or not appearing. Mr. Stepchild, you have made your presentation. I have some serious question whether the Ethics Commission has jurisdiction over that matter. In any case, but is there any other public comment before we adjourn?
Okay.
Do you have a public comment on some other matter?
I wanted to give some more public comment on this matter. I ran out of time.
You've had your opportunity, and I think we understand, and the matter is with the staff at this time. Anyway, do I hear a motion to adjourn?
Move we adjourn.
Second. All in favor?
Aye.
And adjourned. Thank you.
Okay. See you next